is ready to go. All
right. Thank you, Ms. Ona. Hello, Ms. Frick.
Good morning. How are you this morning?
I am okay. We are live streaming.
Great.
So that part's working. So far. Hello there, Miss Hardy.
Good morning.
We are live streaming. Does that show up on your message when you log in? That okay. So
It does.
you actually already know that. Would
did.
somebody who has already joined, has anybody taken the occasion to look at Dropbox recently?
I have not.
I have not either. Not recently.
Well, if somebody could do me a favor and check the Dropbox, I renumbered some things and put the responses to the bench requests in as potential commission exhibits, and I want to make sure that you can see them. So if somebody could, more than somebody, somebody's, we're going to have, as I indicated to you, I think maybe I didn't indicate to you. Did I send you an email on Saturday?
No.
No. We're going to have public commenters this morning before we begin with the evidentiary portion. So far we have 3. Is anybody going to have anything procedural that we need to deal with?
Only that we weren't sure on Friday afternoon if you had questions for Mr. Walters.
And we can address that when we get on the record. I do not.
Oh, okay. All right.
I have questions for Mr. Gorman.
Sure.
I do not have questions for Mr. Walters or Mr. Andrews.
Gotcha. Okay, thank you. We'll let them know.
Okay, anybody else have anything procedural that we need to deal with? No.
Not from SPS.
Okay.
Madam Hearing Examiner, are you talking about these documents that were uploaded to the Dropbox on the 24th?
Yes,
Okay.
I am. That was Saturday.
Yep.
You can see them?
I can see a couple of them.
Awesome. You can see Commission Exhibit 8, which would have been the Attorney General's response to the hearing bench request. Check it out. Let me know. Okay, you can see it. Great.
Uploaded at 2:43 on Saturday.
Yes. Yes, I was working. Were you all not working? Were you all not looking at the Dropbox on Saturday? No, we weren't. We had all of our work done. Okay, well, I'm going to go ahead and while we're waiting, I'm going to go ahead. I've only got one of our three. Maybe I'll wait a few more minutes. I've got one of our three public commenters. If you just joined, hello there, Major.
Good morning, Your Honor.
We're going to have three public commenters before we begin the evidentiary portion of our, or return to the evidentiary portion of our case. And I'm just asking people to check your Dropbox, check the Dropbox. I uploaded some potential commission exhibits, and then I renumbered one of them. The one that I had, the SPP document, I took out, and I had two commission exhibit 2s. So I renamed one of them, I believe, Commission Exhibit 1. And I'm going to confer with Mr. Lee to make sure I haven't violated something that's already been admitted. Looks like Mr. Gorman's ready to go. All right, so no procedural issues. And there was light, Mr. Lee, yay.
Thank you, Judge.
We need to get you one of those little halo things that they got me.
I've got it. I've got one right here, but it's just dark in this room.
But they don't give you any instructions. You know, they don't say, okay, Elizabeth, this is going to make you look like you're 40. You know, if you put it to the side or in front or behind, you know, I think there should be some training with it, don't you think? I mean,
Yeah.
we have all these, don't we have all these movie people here in New Mexico nowadays? There have to be some lighting people that, you know.
I don't think they appear before the PRC.
And we probably don't have the money
Yeah.
to
Could
hire
I
them for a
ask-
training.
Yeah, right. I'm wondering, could we check Mr. Gorman's microphone to see that it's loud enough for you? Because I know he's had troubles with that in the past. I just want to make sure that his microphone is working.
Okay, I'll go ahead and admit him then.
Thank you.
Okay, we're about 3 minutes out. No other procedural matters that we need to deal with.
Madam Hearing Examiner, I don't know if it's a procedural matter like you're asking about, but you had indicated that you might not have any questions for Mr. Higgins and Mr. Bieber. And so it'd be nice if we could let them know if they're expected to testify in the next day or two.
Okay. If I said Mr. Higgins, I misspoke.
Okay.
I have no questions for Mr. Bieber or Mr. Garrett.
Oh, we had planned for Mr. Garrett to go second today. So you don't have questions for Mr. Garrett?
I'm still awaiting to see if the commission has questions,
Okay.
but no, I don't.
But you do have questions for Mr. Higgins, so we should let
I
him-
do.
Okay,
Yes.
thank you.
Yes, sir, I do. And the only other witness I don't believe we talked about on Friday was Mr. Chris. And right now I do not have questions for Mr. Chris.
Madam Hearing Examiner, do you have questions for Steve Barron?
I do.
Thank you.
And was there a witness that we needed to make sure that we got on in the next 2 days?
We had Mr. Garrett who we're planning to accommodate this morning,
Okay,
but that's the only one I'm aware of for the NMLCG.
okay, very well. Okay, well, if we don't have where's Mr. Gorman? Mr. Gorman, do you want to unmute yourself and Ms. Drake wanted to make sure I could hear you.
Uh-oh, I'm texting him to make sure he can, that he's,
There he goes.
okay.
There you go,
he is.
Mr. Gorman.
Huh.
Just say something for me.
Good morning.
Good morning. How are you?
I'm fine, and you?
I'm doing okay.
Great.
All right. I can hear you. You're a little muffled, but okay. All right. I'm gonna put yourself back on mute for me. We have to hear from 3 public commenters, and then we will we'll resume the evidentiary portion of our case. Mr. Lee, are we ready?
Yes, ma'am.
All right. Good morning. My name is Elizabeth Hurst. I'm the designated hearing examiner in case number 22-00286 UT. This is in the matter of Southwest Public Service Company's request for revision of its rates and various requests concerning abandonment and or extension of certain generation plant. We are resuming our hearing that was recessed in the evening of Friday, the 23rd. And today we are beginning with some public comment that we've gotten some requests for. And so I am going to admit the public commenters now. And welcome, public commenters. Good morning. My name is Elizabeth Hurst. I'm the hearing examiner today, and I have been told that you would like to give public comment in this matter. And if we have 3 of you, and if possible, I'd like you to turn your the video. Well, you've gone away from me now. Have the video on, and I believe that Ms. Kippenbrock probably instructed you. Please don't share the link with anyone else. You're welcome after you give your public comment to go on YouTube, and the proceedings are being offered on YouTube, and listen. And I believe, I don't know who 57543000471 is. Mr. Espiritu, is that you? If it is, you need to unmute yourself.
Yes, ma'am. This is Mike Espiritu at the 0471 number.
Very well, sir. You signed up first. Therefore, if you would just give your name and your address and who you're affiliated with, then your 3 minutes would start at that time, sir.
Thank you. My name is Michael Espiritu. I'm at 220 North Main, Roswell, New Mexico. My organization is the Roswell Travis County Economic Development Corporation. Good morning, Mr. Chairman and members of the Commission. Thank you for this opportunity to share my comments on this rate case. We are indeed fortunate to have such a strong economic partnership with the Southwestern Public Service Company. SPS provides sound and reliable utility support to our entire region. We rely heavily on their services, which are critical to our economy, our stability, and our growth. Our collaborative partnership supports the EDC's work in new business attraction and recruitment, as well as supporting the many businesses who have already invested in our region with the hopes of expansion and new job creation. Commissioners, we fully support this rate case as stipulated to help ensure the financial and economic health of SPS as they continue to grow and to help us grow in this region. I encourage your strong consideration to do the same. Thank you.
Thank you, Mr. Espiritu, for taking your time to give the commission public comment in this matter. And sir, if you would just exit the Zoom, and like say, if you want to continue to listen, you can do that on YouTube.
Thank you very much. I appreciate it.
Thank you, sir. And next for our public comment, we have Senator Gay Kernan. Senator, good morning, and thank you for appearing here today. If you would just give your name, your address, and then I will start your 3 minutes.
Thank you, Madam Hearing Officer. My name is Gay Kernan. My address is 928 West Mesa Verde, Hobbs, New Mexico.
Thank you.
Thank you very much, Madam Hearing Officer. Thank you for the opportunity to offer comment on the rate case before the PRC. I am in support of PRC approval of the negotiated stipulation between SPS, Southwest Public Service Company, and the majority of the interveners. Moving forward with the negotiated stipulation would support a fair return on the investment made by SPS in the Permian Basin. This significant investment provides necessary and reliable energy throughout my area, both from a residential and a commercial perspective. During the current hearing, past and potentially future weather situations, as well as the closure of the Maddox and Cunningham stations in my area, have been discussed. Continued investment in grid sustainability and reliability is critical to my constituents. A fair return on investment will provide the necessary energy needs to support the industry and communities that support the financial needs of this area and the state. And thank you very much for the opportunity to comment.
Senator, thank you for taking your time to give the commission your public comment in this matter, and it will be part of the record. Thank you very much. And if you would exit the Zoom, and like I say, you are welcome to continue to listen to our hearings on the YouTube. Thank you. Our next public commenter is Missy Courier. Good morning.
Good morning, Madam Hearing Officer.
Thank you for taking your time to give the commission public comment in this matter. If you would just state your name for the record, your address, and then I'll start your 3 minutes for public comment.
Yes, ma'am. My name is Missy Courier, and I am at 1517 Vineyard Court, Carlsbad, New Mexico.
Very well. Go ahead, please.
Thank you very much for the opportunity to be here this morning and to provide public comment. I am commenting on behalf of myself as a resident of Carlsbad, New Mexico. I am very much in support of the negotiated stipulation that SPS has worked long and hard to come to an agreement on with all of the stakeholders. The reason that we would like to see this move forward is because of the importance not only to the residential, but also to the commercial and business operations that take place throughout southeastern New Mexico. As a resident of this area, it is crucial for us not only to move forward and find comfort and the opportunity to pay for the services that we require here, but also to ensure that we have businesses and operations that are interested in moving into the area that will assist us with the Energy Transition Act. We appreciate your support and look forward to working with SBS further as we continue to diversify our current economy, as well as work to retain our current businesses. Thank you.
Ms. Courier, thank you very much for taking
you.
your time to give the commission public comment in this matter. Your public comment will be of record in this comment. And if you would exit the Zoom, and again, please feel free to listen to the proceedings on YouTube. Thank you. All right. Well, we've had our 3 public commenters so far that were signed up in this matter. And I believe I spoke briefly. There weren't necessarily any procedural concerns. I had one procedural concern. I did upload commission exhibits in the Dropbox on Saturday, and I was just trying to make sure that you all could see them. So if you haven't checked Dropbox recently, you might do that. I've been advised by a couple of the parties that yes, in fact, they could see the commission exhibits. Essentially what I did is I removed the number 1, which was the some kind of SPP statement, and I renumbered that. It was the SPP member value statement. It is now Attorney General response to 1-bench request 5 1-3. So with that, Mr. Lee, well, let me just make sure, because I want our record to be complete. And I believe that the last witness we heard from on Friday was Ms. LeConte. And then for OPL, and I indicated that we were waiving the appearance of Mr. Pollock, and his testimony and work papers were admitted. And therefore, going on with the presentation of the witness order, we would now come to the Attorney General's witnesses. We've already heard from Ms. Crane. Dr. Woolrich will be heard on Wednesday at 9. And I do not have any questions for Dr. Gigax and would waive his appearance. Mr. Gedko, would you like to stipulate in Dr. Gigax's testimony?
Yes, I would. Mr. Gigax's direct testimony. The direct testimony of Doug Gigax on behalf of the New Mexico Attorney General, which is labeled as NMAG Exhibit 2, was uploaded to Dropbox. The document meets the criteria for the submission of stipulated testimony. And the version that I would like to enter into the record, stipulate into the record, is the version that I uploaded to Dropbox.
Very well, Mr. Gedko. Any objection to what's been identified as New Mexico Attorney General 2, Dr. Gigax, direct testimony filed in this proceeding that was uploaded into the Dropbox and has been verified as meeting the requirements to be stipulated in to the record without the appearance of the witness. Hearing no objection, New Mexico Attorney General 2 is admitted. And I believe Mr. Getko, then we will await hearing from Dr. Warwich on Wednesday. Anything further from the Attorney General at this time?
Nothing further at this time. Thank you, Madam
Very
Mayor.
well. Thank you, sir. That brings us to our next party. And this is LES and FEA. And I believe LES and FEA have 3 witnesses. And I have no questions for LES FEA witness Walters, nor for LES FEA witness Andrews. Ms. Drake and Major, would you like to go ahead and either Major Buchanan or Ms. Drake offer those testimonies into the record?
Yes, Your Honor, this is Major Buchanan.
Go ahead.
First is the direct testimony and attachments of Christopher C. Walters, which is labeled as LES FEA Exhibit 1. And I can represent that this exhibit meets the criteria for stipulated testimony and that the version that I'm seeking to admit is the same as the one that was uploaded to Dropbox.
Very well. Any objection to what's been identified as LES FEA Exhibit 1, the pre-filed direct testimony of Mr. Walters that was placed in the Dropbox, and that counsel has verified that it meets the requirements to be stipulated in without the necessity of the witness? Hearing no objection, LES FEA Exhibit 1 is admitted.
Thank you, Your Honor.
And go ahead, Major.
Next is the direct testimony and attachments of Brian C. Andrews, which is labeled as LES FEA Exhibit 2. And I can represent that this exhibit complies with the requirements for stipulated testimony and that the version I'm seeking to admit is the same as the version uploaded to Dropbox.
Any objection to what's been identified as LES FEA Exhibit 2, Mr. Andrews' direct testimony that was filed with the commission, placed in the Dropbox, and that counsel has verified that this testimony meets the requirements for stipulation into the record without the necessity of the appearance of the witness? Hearing no objection, LES FEA Exhibit 2 is admitted. Major, Ms. Drake, you have a
Thank you.
witness.
Yes, we do. We would call Michael P. Gorman.
Thank you. Good morning, Mr. Gorman.
Good morning.
I'm getting ahead of myself here, Mr. Lee. Have we already sworn, Mr. Gorman?
No, ma'am.
Would you swear the witness, sir?
Yes, Your Honor. Mr. Gorman, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and upending should be the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes.
Thank you, sir.
Thank you, Mr. Lee. Go ahead, Ms. Drake.
Thank you, ma'am. Good morning, Mr. Gorman.
Morning.
We're hearing you, but a little faintly. If you could get a little closer to your microphone, that would be helpful. Thanks. Could you please state your name for the record?
My name is Michael P. Gorman.
And by whom are you employed and in what capacity?
Employed by Brewbakers and Associates as a managing principal.
And on whose behalf are you testifying here today?
LES Corp. And federal executive agencies.
And do you have in front of you the document labeled LES FEA Exhibit 3?
My direct testimony, yes.
So does that include your direct testimony and attachments of Michael P. Gorman?
It does, yes.
That's great. Was this exhibit prepared by you or under your direct supervision and control?
Yes.
Do you have any corrections to your testimony or your attachments?
I do not.
If I were to ask you the same questions today, would your answers be the same?
Yes.
Are your answers in your testimony and the information in your attachments true and correct to the best of your knowledge and belief?
Yes.
And can you represent that? I would represent to the hearing examiner that LES FEA Exhibit 3 is the version of Mr. Gorman's direct testimony and attachments that was uploaded to the Dropbox. And with that, I would move for admission of LES FEA Exhibit 3.
Any objection to what's been identified as LES FEA Exhibit 3, Mr. Gorman's direct testimony as verified by him here today, and whose testimony was placed into the Dropbox, and that is the version of the testimony that is offered as LES FEA Exhibit 3. Hearing no objection, LES FEA Exhibit 3 is admitted. Ms. Drake?
Thank you, ma'am. Mr. Gorman, do you have in front of you the document that I've labeled LES FEA Exhibit 4?
I do, yes.
And can you identify what that is?
That is my testimony in support of the stipulation in this case.
Does that testimony include any attachments?
It does not, no.
It does not. Okay. Was this exhibit prepared by you or under your direct supervision and control?
Yes,
And do you have any corrections to your testimony?
I do not.
If I were to ask you the same questions today, would your answers be the same?
They would.
And are your answers true and correct to the best of your knowledge and belief?
Yes.
I would represent that LES FEA Exhibit 4 is the version uploaded to the Dropbox, and that is the exhibit that I am moving for admission of LES FEA Exhibit 4.
Thank you, Ms. Drake. Any objection to what's been identified as LES FEA Exhibit 4, Mr. Gorman's stipulation testimony as verified by him here today and as represented by counsel that the version of LES FEA Exhibit 4 was placed in the Dropbox to be admitted? Hearing no objection, LES FEA Exhibit 4 is admitted. Ms. Drake?
We have no questions for Mr. Gorman at this time, so I would pass the witness for cross-exam, or actually, I don't believe there was any cross-exam for Mr. Gorman, so I would pass him for examination by the hearing examiner and any commissioners who might be in the hearing this morning.
Thank you, Ms. Drake. I've got a few questions for you, Mr. Gorman. Again, welcome. Good to see you again.
Nice to see you. Thank you.
And just so that it's on the record, you're appearing on behalf of LES and FEA. Can you tell me what kind of service of the classifications of service that SPS provides? do your clients usually take from?
We are on large general service transmission rate from SPS.
And there's another party that you're probably familiar with in this case called the New Mexico Large Customer Group.
I am familiar with them, yes.
Do you take service any differently, or how do your interests, are they the same as that? Is that party, or are they different?
You know, I didn't look at that specifically for this testimony. It's my understanding, but I have not verified it, that the LCG customers are largely on large general service, primary and transmission service. So 69 kV and the bulk transmission system, 100 kV service and above.
So the same as LES and FEA?
I believe so, generally, yes.
I just wondered whether or not, what type of services does, what type of company is LES or companies?
They are a mining company, an enrichment company. FEA is military based predominantly.
And I just wondered if those particular clients have any particular service characteristics or or usage characteristics that make them different from, say, like another large general service transmission customer.
They are both high load factor services. I think that probably is fairly common characteristics of the large general service transmission level customers on the system. I think their load factor is very high relative to many other customers on the system. And their delivery voltage is, of course, at sub-transmission level delivery, as opposed to customers that take service at lower delivery distribution voltages, such as primary and secondary.
Sir, your testimony, your direct testimony in this case, you indicate that you're addressing the reasonableness of SPS's jurisdictional allocations, its retail class cost of service study, and the spread of the approved revenue increase across the rate classes. You also address any adjustments you think are appropriate regarding the large general service transmission rate 34, correct?
Yes.
And in providing this particular testimony and the testimony of the other LES FEA witnesses, Mr. Walters and Mr. Andrews, you come up with a claimed revenue deficiency, which actually wasn't a deficiency at all, was it?
It was not. No, that's correct.
And the conclusion was that perhaps there was a revenue surplus of $2.8 million, correct?
That is correct, yes.
And your conclusion, at least for your part of the testimony, indicated that, among other things, you thought that what you termed to be the significant and material projected increases in the large commercial and industrial customers that those projected increases, along with the loss of wholesale customers, caused SPS to have increases in the jurisdictional allocation factors that you thought weren't based on known and measurable changes. Correct?
Correct.
And part of the correction for that, in your testimony, had to do with correcting those factors primarily to reflect both the capacity and energy for wind and solar resources. Correct?
Well, I think there's two issues there. One, the correction was on the development of the jurisdictional allocation factors for production capacity and energy, to reflect billing units that were known and measurable, as opposed to the projected change in billing units, which had the effect of increasing New Mexico jurisdictional allocation numbers. The other issue in my testimony dealt with the classification of certain production costs, where the company had classified some renewable resources as energy only. I recommended that they be classified more as production, particularly recognizing that the production allocation factor used for retail class cost of service was driven by both base energy requirements and excess energy requirements, which I felt was reasonable for all production resources, not just the thermal generation resources.
Additionally, you also recommend that there be a different allocation for purchase power agreements.
I did. Again, similar to company owned renewable resources, they also have renewable resources under purchase power agreements. Those purchase power agreements provide capacity and energy benefits to their system. Company proposed to classify those PPA resources as energy only because they provide both capacity and energy benefits. I recommended that it be classified on the basis of both the capacity and the energy benefits they provide to the system.
Additionally, you recommended that with regard to the rates for the large general service transmission, that there be an equal percentage change in the demand component and the non-fuel energy component, didn't you?
I did, that's correct. And that's kind of a follow-on of that classification issue for renewable production resources. Since they provide benefits for both capacity and energy, then the customer should pay for those resources based on both capacity payments and energy payments.
And then you also recommended an equal percent change in the demand and the energy rate components to cure the revenue assignment to the large general service transmission rate class, correct?
Correct, yes.
And then finally, your other large part of your testimony had to do with trying to get, I guess, the conversation going on time of use rate design.
That's correct, yes.
So of these recommendations, how did you do when it came time for the stipulation?
Well, for the stipulation, all of those issues were as part of our strategy for negotiating a settlement, which we felt is reasonable both to the company and to us and to other parties in the case. So the allocation of jurisdictional allocation factors, some of the numbers we thought were not known and measurable were not known to the extent they meet the known and measurable standards for rate-making purposes. But some of the changes were reasonably estimatable to reflect changes in cost of service in this case. So we looked at, based on a detailed review of the company's cost of service study and all the support they provided in response to discovery in both direct and rebuttal case, we outlined ranges for resolving the jurisdictional allocation issue, as well as the rate of return issue, the depreciation expense issue, particularly with respect to accelerated recovery on certain coal-fired units, which also, by the way, was an issue we had with the jurisdictional allocation factors for changing them immediately at the point where customers were being asked to pay accelerated recovery on production resources that had previously been used to provide service in prior periods. We were concerned about retail customers being stuck with production resources that had previously been used to provide service to other jurisdictional customers. And now that they are leaving and there's abandoned plant cost or costs that will not be spread over the originally estimated service life of those facilities, would instead be allocated back to retail customers. So we look for a way of resolving all of those issues within the settlement. And we found that the revenue requirement that was agreed to within the settlement, with a little give and take on many of those issues, as well as some issues the other parties were raising, provided a reasonable resolution of these disputes that we had with the company in measuring their cost of service. And in terms of the other parties in the case, in the company, the issue of classification of production resources, both capacity and energy components, went into describing the allocation of the revenue increase across the various rate classes, was part of the settlement process and the give and take with all the issues of all the parties in the case, including the company. And finally, the adjustments to the rate 34 customers, rate components, non-fuel rate components, was an important consideration for resolving the issues in the case. So the settlement, we went through in painstaking detail all of those issues to try to resolve them in a reasonable manner that we felt was fair to both the customers and to the utility, generally, and to LES and FEA specifically.
There wasn't necessarily a change agreed to with regard to the jurisdictional allocation of wind and solar, was there?
Not explicitly, no, but the spread across the rate classes gave way to all the parties' position on that issue and resolved the issue in a way where agreed to the spread without agreeing specifically to the class cost of service study.
And I don't know if you were listening, but I thought I heard on Friday when I was looking at the stipulation exhibit. I can pull that up. The signatories. So this is page 1 of Exhibit A to the stipulation.
Okay.
And it just shows the increase. That's one of the bench requests, is that I like the original one. I want to know what the overall how the overall increase affected the classes. But for our purposes here today, we can just look at the overall increase for the base and essentially 10.2 for up Elizabeth, 8.49 for large general service transmission. Is that correct?
Yeah, after the reflective roll in the base rates of certain rider mechanisms, yes.
And without me pulling up the original one, can you say generally that this particular rate class increase for large general service transmission in the stipulated revenue requirement is a lower percentage than it was originally proposed by SPS?
It is, yes. And again, that largely reflects a compromise on the classification of production resources.
So if we were looking at reasons for you and your clients to support the stipulation, that probably would be one of them, right?
That was an important issue to us, yes, because we feel the renewable resources provide both capacity and energy benefits to the system, and that all customers should pay for the benefits in proportion to the benefit, to what those resources provide the system.
And I thought I heard on Friday that for the large general service transmission customer, that the percentage increases were equivalent between demand and non-fuel energy.
I'm sorry, could you repeat that question, please?
Sure. One of the things I know that is included in your testimony is you wanted to see more equal percentages in certain components, like demand and energy. And I'm just wondering if that was accomplished in this settlement.
Well, it was, but that was a rate design issue for the large general service transmission rate. We're adjusting the rates to increase the revenue collection from the class to accommodate the change in cost of service to that class. The issue for allocating production resources across the rate classes was to come up with, the issue I raised was to come up with an allocation factor for renewable resources that allocated those costs on more than just an energy basis, because those resources provide both capacity and energy benefits to the rate class. And I argued that the average and excess methodology, unlike a direct coincident peak type methodology, is a more appropriate allocation factor for renewable resources, because renewable resources provide energy to serve both base demands and demands in excess of base, consistent with how the average and excess production demand cost allocator is developed.
I'm sorry, demand in excess of?
The demand, production demand, average and excess allocator is developed.
Thank you, sir.
So you're telling me it's a rate design issue? Was that specifically addressed?
I am telling you that, but it's really a two-part issue. One is a class allocation issue, for developing a production cost
Right.
allocator, step number 1 and step number 2. Then within the LGST rate class, it's a rate design issue.
And were either or both of these addressed in the stipulation?
There was compromises on both, yes. And they were both addressed in the settlement, yes.
As part of the comprehensive package of things or explicitly?
Explicitly. In the
Okay.
in the revenue spread across the rate classes, there was a compromise on the results of a class cost of service study. Class cost of service study was not part of the settlement, but the spread across the rate classes in line with cost of service was included in the settlement, so that there was a compromise on class cost of service study. Within the design of the LGST rate, there was accommodation made for our position on classifying renewable production as both capacity and energy benefits to the rate class.
On page 7 of your direct testimony, you asked the question beginning at line 12, in developing its future test year revenue requirement, did the company project that jurisdictional allocation factors have a meaningful impact on the estimated revenue deficiency for New Mexico retail operations? And you begin your answer on line 17 on page 7 saying yes, and then you go ahead on to page 8. And what I'd like to ask you about is lines 2 through 5 on page 8 that said, had the company relied on actual jurisdictional allocation factors for the base period, the claimed revenue deficiency in the forecasted test year would have been $33,944,007 for the New Mexico retail operations. That was your testimony?
Yes.
Did this particular fact that you testify about have any impact on your decision to agree to the stipulated 33 million?
Well, it was one of the issues that we tried to resolve in settlement, yes. And the significance of this is that if the company used a forecasted test year, and in their forecasted test year, they were projecting very large increases in sales to New Mexico retail customers, which increased the jurisdictional allocation of cost to the New Mexico retail operations. So there was a gray area there on that issue, whether or not the commission would ultimately adopt our position that those projected sales growths were not known and measurable relative to the company's position, where they believed they had evidence supporting the change in the sales levels and that jurisdictional allocation factors should be modified. So the give and take in the settlement negotiations accommodated the potential range of outcomes on this issue in arriving what we believe to be a fair resolution of the rate case.
Well, I guess I just wondered if it gave you some feeling of comfort that they wanted at the time you filed your testimony, they wanted 76. You thought that based on what they had presented, they should get a minus 2.8, but yet you say in here, well, if they had changed the way that they and hadn't added all that increase, I'm assuming, then they would have come out with 33.9, which is, pretty close to the 33 that you agreed to.
Well, I mean, that's kind of a coincidence. The 33 was based on a long negotiation between all the parties, not just us and the company.
All right, so you've answered my question. It wasn't really this number. It's a coincidence then that this number that you have in your testimony, it wasn't like a benchmark for you in your negotiations.
That's right. Yeah.
Okay.
We reached a review of the settlement based on many factors that went into measuring cost of service in this case.
Okay. Sir, on page 14 of your direct testimony, the question posed at line 1, why do you conclude that the increase in C&I customers and related sales are based on the statistical trend line analysis, but are not supported by known and measurable changes to the SPS number of customers and sales in the forecasted test year? So you're talking about you did some discovery, and in your conclusion of that discovery, I think at line 19, rather, it simply projects adding customers based on customer addition trends from past periods. That's your testimony?
It is, yeah. When we were looking at the company's original projected test year, we were looking at the reliability of their projected changes in cost of service relative to the base period, and their projections for significant increases in load in the New Mexico retail jurisdiction was one of those issues we noted. We did investigations into it and found that, you know, the company's projections were, in my judgment, largely based on statistical trending methodologies, as opposed to specific identification of customers that they knew would come on to the system in the forecasted test year. And my conclusion was, at the time I wrote this testimony, is that those additions of customers were not adequate to support the reallocation of the total system cost in a manner that increases what is assigned to the New Mexico retail jurisdiction.
Well, based on your knowledge and experience, Mr. Gorman, do other utilities forecast their projected sales and load growth in a different manner?
Well, they all use statistical trending methodologies, but an economic analysis can provide useful information, but it's not necessarily adequate to impose large increases in charges on customers. So to the extent that there's not supporting evidence to back up the results of the statistical trending methodology, I frequently will take issue with the company's projected change.
No, I was just trying to figure out if other companies provide the same information, but utilize sources that are different, that you find are more accurate or reasonable.
But not from a statistical modeling standpoint. I didn't take issue with that aspect of it. Rather, more of a rate making standpoint is when there's significant estimated changes to cost of service, there needs to be more concrete, known and measurable evidence to support that change in cost of service. And that's what I found was lacking in the company's filing.
You also took issue with SPS's assertion that because of the wholesale contract loss, that they really didn't need as much projected capacity as they were claiming, correct?
Indirectly, yeah. They, in the forecasted test period, without the wholesale customers, they still had more capacity than needed to serve their retail native load obligations along with their wholesale contracts. So I took issue with the company's loss of a wholesale customer without a concerted effort to try to find a new wholesale customer to sell that capacity to the extent that the capacity price they would get with the new wholesale customers was lower than what they would get from retail customers is not justification for foregoing the new wholesale contract and instead shifting those costs to retail customers when the capacity isn't needed to serve retail customers. So that was more of the underlying rationale for rejecting that aspect of the company's proposed change in jurisdictional allocation factors.
Additionally, in your testimony, sir, on page 22, you are addressing Hale and Sagamore resources, also the wind PPAs. And you state in your testimony that as part of the agreement that the parties had in the 17, I think there might be an extra zero in there, 00044, the Hale and Sagamore CCN case, the parties had agreed to use an energy allocator for the first rate case for each of these facilities after the units were placed in service, correct?
Yes.
And you go on in your testimony to say, okay, that's been done now. And now it's time to look at this differently, correct?
Yeah, yes, the circumstances change, and they were anticipated to have the probability of changing at the time the settlement was entered into, at least by certain members of that settlement, including LES.
That specific issue was not addressed in the stipulation, was it?
It was implicitly in that there was an agreement to use a jurisdictional and class energy allocation factor in the first rate case. But to the extent those resources, the benefits of those resources changed, then the allocation of the cost of those resources across jurisdictions and retail classes could be revisited in subsequent rate cases. So with that provision, I think it did accommodate the expectation that the benefits of those resources could change over time.
And I'm sorry, I was not clear enough in my question. And I guess that was confusing stipulations. I had actually morphed to ask you about the stipulation in this case and to ask you whether or not the stipulation in this rate case addresses any change in allocation.
No, you are correct about that. We did not reach an agreement on how to change class cost of service in this case, but we did compromise on the class revenue spread.
And do you believe this is going to be an issue that we're going to hear from again?
I think it is, because I think the company's resource mix is changing to the point where they are now relying on renewable resources for capacity system needs to maintain reliable service, where that was not the expected benefit to these resources, 5 years ago or so, 6 years ago, when these resources were expected initially to be a benefit to customers because they would produce energy savings. So going forward, as the company continues to modify its production resources to meet the zero carbon mandate, renewable resources are now capacity and energy suppliers to the system, which accommodates a change in the cost allocation of these resources to ensure that all customers pay a fair share of those resources costs that are in line with the benefits those resources provide the system.
And could you provide me an illustration of your testimony on pages 33 and 34, where you're answering the question on page 33 posed at line 9, why would the allocation of the Hale and Sagamore production fixed cost allocation on energy not be a reasonable, accurate allocation of these costs across SPS's New Mexico retail classes? And So you're talking about that the company operates its production in order to minimize its hourly energy generation costs, relies on the production of all of its resources for the varying load imposed on the system. Because the resources vary in proportion to the customer's average loads and excess average loads, SPS's proposed allocation of Hale and Sagamore would not be proportionally spread across the customers based on their demands on the system.
Well, I'll do my best, but the idea is the average and excess production allocation factor takes the company's total production cost and assigns a certain amount of that cost to serving base energy requirements, an amount of that total cost being used to serve energy demands in excess of the average base. Those production resources from these renewable resources are fixed. So if you allocate those costs only on the base energy requirements, then customers that have demands in excess of base will not pay for the fixed cost of those resources in proportion to how those resources are used to provide energy during the excess demand periods, which is what the company is proposing, in my view, using only an energy allocation factor. So modifying the allocation of these production resources to assign cost across rate classes, both in proportion to the system's base energy demands and also a portion in relationship to the rate classes excess energy demands, allocates the fixed cost of these resources on the energy allocation factors, but in proportion to how each class contributes to the company's base energy demands and the system's excess energy demands.
Thank you. So if they allocate it only on energy and don't have any costs associated with demand, the customers that are using the excess demand are never being charged.
Yeah, that's right. They're paying, that's right. They don't get a portion of those costs that are being used to provide energy for those excess demand periods. They're not getting a portion of those costs in those excess energy charges.
I also wanted to ask you about page 47 of your direct testimony. And that's when you're making the additional recommendation regarding the time of use structure. And that particular issue was in fact settled in the stipulation, wasn't it?
To investigate, yes, to investigate it in a cooperative, structured workshop where everybody committed to make a concerted effort to do a detailed review of this issue.
And that is, I believe, in the rate design and tariff issues, section 19.
Of the stipulation.
Yes.
Double checking, I apologize for. Yes, it is.
Do you think that the requirements in this section are sufficiently set out to avoid any difficulty regarding what's required of the parties and when?
It was designed to be a constructive workshop and try to avoid some of the problems that prior workshops have had in discussing rate making issues and rate design issues. So that it
Well-
was specifically designed with that in mind.
Well, you know me, I'm more concerned with prior cases and prior agreements and stipulations not being sufficiently clear to set forth exactly what needs to be done. But you think this is designed to avoid any particular issue, say like in the standby case?
Yeah, that it is designed for that. And I would note that once you get into the workshop, you come into issues which you didn't anticipate, which you have to resolve, try to resolve within the workshop. And the standby case did raise a lot of those issues. But this structure of the workshop is intended to streamline the process and get cooperation, constructive cooperation from all the parties in the workshop to accomplish, a constructive evaluation of this issue and offer either a settlement to the commission on the issue or identify ranges of parties' positions that would resolve the issues.
Are you glad you have a standby rate now?
I think clients are happy to have that as a way to investigate opportunities to manage their cost of utility purchases. Yes.
In your testimony in support of the stipulation, you indicate on page 3 that the ROE of 9.5 and the resulting rate of return of 7.17, basically along with everything else, it is you think it's going to support the SPS credit metrics and investment grade bond rating and will do so at reasonable tariff rates to New Mexico customers.
That's correct. Yes.
And that it was within the range of the various parties, I believe, including LES FEA. Didn't your witness have a range of 8.8 to 10
That's correct. Yes.
with a midpoint of 9.4?
Correct. Yes.
So 9.5 was pretty close to the mark on that then, wasn't it?
Close to Mr. Walters' recommended midpoint estimate. Yes.
You also indicate in your testimony when discussing the various sections of the stipulation, section 6, which is the cap on rate case expense. You believe that's reasonable?
I do. Yes. I believe that the company was able to limit their rate case expense by entering into settlement negotiations with the parties.
And when you're talking about the revenue deficiency on page 6 of your testimony, you did say the parties did compromise on the spread. of the revenue increase to reasonably reflect a range of cost of service study results, correct?
Correct, yes.
And I got a little confused at the end of the day last week, but can you see, I think I have my screen share on.
Yes,
Can you see the page one?
I can. Yes, I have that available here too, so I can see it.
Okay.
Yes.
So when you're talking about the spread, are you talking about how the revenue increase is allocated to the rate classes? And in this particular instance, the spread would be the lowest increase is going to be 54%.
Well, that's the class percentage distribution of
Sorry.
3 million. Yeah, the percent change in the class is shown in
On the this
yeah,
under the
second to last column.
okay.
Correct, yes.
So but when I'm looking over here at the settled customer class revenue distribution, the 54% is the low and the 145% is the high, correct?
Correct.
Okay, so is that what is considered the spread?
Well, yeah, if you look in the two columns, in the middle column, step one increase, and then adjusted increase 2 columns over, that column, particularly adjusted increase, shows how the $33 million increase in total system revenue is spread across the various rate classes. So then the next column shows the percent change in revenue to current rates that increase in the class revenue realizes to show the relative percent spread in by rate class.
In column B.
Yes. So this table shows in the very first column, current revenues are about 474 million. And after a $33 million increase, the final column shows 507 million. So the change in each of the rate classes to go from column one to the last column. This schedule shows the math and adjusting each rate class's revenue to get from the beginning to the end point.
Okay. So just so that I'm clear, in your testimony on page 7, when you say the stipulation provides for an increase of no more than 150% of the system average increase, nor less than 50% of the system average increase for any specific rate. You're talking, go ahead, sir. Explain that.
Yeah, the second to last column, you see a system average increase of 6.96. So on a very rough basis, no class would give more than 1.5 times that amount of increase, or roughly 10.5%. No class would get less than 90% of the 6.96%, or 5.5% looks like area lighting got.
Okay.
5.5%, it looks like.
The area lighting service class received.
Very well, sir. Those are the questions that I had for you. Um, Mr. Chair, did you have any questions for Mr. Gorman?
Just a couple. Thank you.
Thank you, sir.
Good afternoon, Mr. Gorman.
Good afternoon, Chairman.
I just have a couple questions for you. Just been trying to explore the stipulation here and been asking a lot of the cost of service witnesses if in your work in this case or other things, do you have any way to quantify how much the NOx allowance costs will add to cost? And I'm talking about the NOx allowance costs in paragraph 8 of the stipulation.
I have not quantified the additional NOx allowance cost.
And then are you just broadly unconcerned with that amount as far as your customers go? Or I mean, why was there no quantification?
Well, we look at this case, that's more of a cost that will depend on the dispatch of the company's generating resources, which will drive the cost of that dispatch, which would include the NOx cost. So that's more of a fuel adjustment cost item. This case primarily concerned non-fuel cost of service items. So when we negotiated the settlement in this case and investigated the cost of service items, we typically separate the non-fuel cost of service items, which is what was issue in this case, versus the fuel cost issues, which typically would relate to a fuel adjustment cost proceeding. Way to just administratively kind of look at all the costs, but do so in a manner that allows for a structured review of these costs, which in both instances require a lot of investigation.
Yeah, thank you. And then that frankly leads to my next question. Stipulation determines that these costs will be in the fuel clause. And one of the reasons I'm asking this quantification question is I just want to understand how much volatility that might add to the fuel clause. So 2 questions. Does volatility in the fuel clause concern your customers? Is the first one.
It does, yes.
And then second, you said that these type of issues will be looked at in a future FPP CAC proceeding. If stipulation's approved, I'm reading it to mean that baked into the proceeding, the NOx adjustments will just be part of the FPP CAC. Is that your understanding also?
It is, yeah, but we will investigate, whether or not the company is utilizing its generating resources to minimize its cost of generating energy. So part of that dispatch cost then would include what NOx taxes may be and, and other impacts on the dispatch cost of various generating resources.
So if it looks like that item might be better handled somewhere other than just an automatic adjustment clause, and just for sake of argument, to ensure the company has an incentive while it's choosing how to present its resources for dispatch in SPP. Is there any way to get it out of the fuel clause if the stipulation is approved?
Well, just because it's being handled in the FPP CAC does not mean that the company's actual cost of generation will be passed through to customers. We will have an opportunity to show if we believe the company has not managed its resources in a manner to minimize its fuel cost, that some of those fuel costs are not appropriate for passing on to customers. And that would include whether or not it's utilizing its resources in a way to minimize cost to customers, which may include dispatching the resources in a way that minimizes environmental adders. on use of those generating resources. So it is an automatic adjustment mechanism, but to the extent the costs being incurred are not reasonable and prudent, they can be challenged.
And just for the sake of making sure I understand it, you're saying it can be challenged in these future fuel clause proceedings.
My understanding that, yeah, you can challenge from a prudent standpoint whether or not the company is operating its generating resources in a prudent manner to minimize cost to customers.
Thank you. Next question is just, do you participate in SPS as integrated resource planning processes?
I have not been a witness in them, but I have participated in it on behalf of customers of SPS, yes.
And as someone who has participated in those processes, do you believe that, like it says in paragraph 16, that the company, that is paragraph 16 needed to ensure that the company provides a forum for interested stakeholders to discuss timing of replacement resources to address retirement of TOLC and other SPS system needs?
I believe it is, yes. Often the selection of a production resource or even capacity expansion for transmission facilities can be the main issue driving a need for changes in revenue requirements for rate cases, for non-fuel revenue requirement issues. After the utility has made the decision to go ahead with the capital program and the rate case comes along to recover that cost in adjustments to rates, it's a little too late then to challenge whether or not they were making a reasonable and prudent resource selection decision. So customers typically are allowed to participate in the integrated resource plan in order to encourage the customers to make sure that the utilities are making the best resource selection options available to it up front prior to the time the utility actually incurs any capital investments to pursue a resource.
Yeah, no, I agree. That is a shared view of how the process pieces are supposed to fit together. I guess I'm not sure I asked the question very well, but absent paragraph 16, is there any reason to believe that SPS would deny stakeholders the forum that's described in that paragraph?
I don't know that SPS actually has, but I do think I have experience with other utilities that have not been so transparent with their resource plans. Regulatory commissions typically require them to allow a process where customers can have a voice in it. I'm not aware of SPS ever preventing customers from having a voice in that process. But the settlement kind of outlines a cooperation between SPS and all the stakeholders in this rate case. Kind of emphasizes that all customers, all stakeholders benefit from a cooperative engagement in rate cases and fuel cases and resource plans. And I think this settlement kind of emphasizes the benefit to all stakeholders from that standpoint.
Well, thank you for that. And those are all my questions. I appreciate your testimony in this proceeding, Mr. Gorman.
Thank you.
The floor is yours, Ms. Hurst.
Thank you, Mr. Chairman. Ms. Drake, is there any redirect for
No,
Mr.
ma'am.
Gorman?
No, ma'am, I don't have any redirect at this time. Thank you.
Any questions from the participants based upon my questions or the questions by the chair? Hearing none. Mr. Gorman, thank you again, sir. Have a good afternoon and you're excused.
Thank you very much. Bye-bye.
Goodbye. Ms. Drake, Major Buchanan, anything further from LES FEA?
Not at this time. Thank you.
Thank you. And looking at Our next presentation then, the next party is the large customer group. And I believe that I have previously indicated that I do not have questions for Mr. Garrett and would entertain a request to have his testimony stipulated in. Additionally, I do not have questions for Mr. Bieber and would entertain a request to have his testimony stipulated in. So that would bring us to Mr. Higgins, who I do have questions for. And I believe now might be the appropriate time for us to consider taking the luncheon break, and would just say that after Mr. Higgins, the next party in the list is COG, and I do have questions for a few questions for Mr. Barron. After that, the next party would be Sierra Club, who's already presented its witness. So then the next party would be Walmart. I do not have any questions for Mr. Chris. Would entertain a request to have Mr. Chris's testimony stipulated, and then that would bring us to staff if we get to staff this afternoon. And so after staff presentation, then we'll hear from CCA witness Long. And I think I've already indicated, but if I haven't, I don't have any questions for CCA witness Batts, and would consider having Mr. Batts' testimony stipulated in. So that's kind of how I see us going this afternoon. We'll get through as many witnesses as is appropriate. But for right now, it's 12:30 and we are recessed until 1:30. Do I have any procedural questions? No. Okay, thank you all very much. Remember, we have YouTube still streaming, and we are recessed till 1:30. Thank you. Okay. Okay. Very well. Mr. Lee, are we ready to go back on the record?
Yes, Your Honor.
All right, thank you. I have been given a bit of different information since before the luncheon hour. And good thing we're all flexible. It is my understanding that there are questions for Mr. Walters and Mr. Garrett. And I see that Mr. Garrett is in the waiting room.
Yeah, that's correct, Your Honor. This is Nick Stoffel. We had him available just in case he needed to be called to the stand.
Great. I appreciate that. And why don't we go ahead and I'll go ahead and admit Mr. Garrett. And perhaps we can go ahead and admit his testimony at this time. Go ahead, Mr. Stoffel.
Good afternoon, Mr. Garrett. Can you hear us?
I'm sorry, I need to swear the witness.
I was just
Oh, sorry. There you are,
Yes.
Mr. Garrett. I was trying to find your picture. Okay, Mr. Lee, would you please swear in Mr. Garrett?
Yes, Your Honor. Mr. Garrett, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Thank you.
Go ahead, Mr. Stoffel.
Thank you. Good afternoon, Mr. Garrett.
Good afternoon.
Will you please state and spell your name for the record?
My name is David Garrett, Garrett.
By whom are you employed and in what capacity?
I'm the managing member of Resolve Utility Consulting.
Did you prepare direct testimony and attachments on behalf of the New Mexico Large Customer Group and Occidental Petroleum in this proceeding?
Yes.
So do you have a copy of that testimony that has been marked as NMLCG Exhibit 3?
Yes.
Was this document created by you or under your direction?
Yes.
Do you have any corrections to your testimony?
No.
If I were to ask you the questions in your direct testimony here today, would your answers be the same?
Yes.
Thank you. I move for the admission of Exhibit NMLCG 3.
Mr. Garrett, did you have any attachments to your testimony?
Yes, I did. Which I label as exhibits, but from 1 to 28, it looks like.
And those were prepared by you or under your direction and control?
Yes.
And Mr. Stoffel, the version of New Mexico Large Customer Group Exhibit 3 that was placed in the Dropbox is in fact the version of the witness's testimony that you would like to offer here today?
That's correct. PDF totaling 304 pages.
Very well. Any objection to what's been identified as New Mexico Large Customer Group Exhibit 3, the pre-filed direct testimony of Mr. Garrett that was placed in the Dropbox as verified by Mr. Garrett here today? Hearing no objection, NMLCG Exhibit 3 is admitted.
Thank you, Your Honor. And Mr. Garrett is available for questions.
Very well. I did not have questions for you, Mr. Garrett. I think I understood your testimony, but it's my understanding that one of the commissioners has questions for you. But let me go ahead. I don't see that commissioner is available at this time. But suffice it to say, Mr. Garrett, you were not in agreement. Well, let me start out with, your area of expertise in presenting testimony had to do with the return on equity. Is that correct?
Yes.
And you were not in agreement with what was being proposed by SPS, were you?
In their pre-filed testimony, no, I was not.
And what was the return on equity that you testified that you believe, based on your review of the evidence, was appropriate?
Well, just to make one distinction, I'm in a way testifying on two numbers. In this case, they do actually happen to line up, but my cost of equity estimate, the range of my models indicates a cost of equity range of 7.9% to 8.7%. The awarded ROE, while I think should be directly very closely related to the concept of cost of equity, is kind of a second matter to consider. I think the awarded ROE should be generally reflective of cost of equity, but of course, it ultimately just needs to be reasonable under the circumstances, and that can consider a whole range of factors. So I, in this case, estimated SPS's cost of equity to be 8.7% if a corresponding adjustment to the rate-making capital structure was made to where SPS's rate-making capital structure would be the same as the proxy group average. So in this case, I indicated, I recommended a cost of equity estimate of 8.7%, and that was also my awarded ROE recommendation.
But I believe that you indicated that if there was not such an adjustment made, that the appropriate ROE was 7.9.
Yes, once I'd estimated the 8.7% under the CAP-M, it really must be mathematically adjusted to make whatever your utility you're studying. They need to have their indicated capital structure adjusted to the proxy group, really. So in this case, it would have to be lower because SPS has more equity in their capital structure than the proxy group does. So it's almost just kind of a mathematical fallout at that point. Once the 8.7% is estimated and you have the capital structures of the utility you're studying and the proxy group, using a model that it's been around a long time, but it's called the Hamada model. Yes, you're right. It would be adjusted down to 7.9%.
Mr. Lee?
Can you spell?
Spell that. Yes, it's named after the person who created it, but it's H-A-M-A-D-A.
Thank you.
And I'm sorry, sir, what was your proposed adjustment to the common equity number?
Well, there's kind of two parts. I guess what I'm saying is SPS's cost of equity, in my opinion, was 8.7%. If its rate making capital structure is adjusted to the average capital structure of the proxy group, which includes 55% long-term debt and 45% equity.
That's a pretty significant change from what SPS proposed. Isn't it, Mr. Garrett?
Yes, that's a significant difference.
I mean, they were proposing
the inverse, basically. Yeah.
Yeah, 54.7, didn't they?
Yes, for equity, yes.
But you think it should actually be adjusted down to 45?
Well, so I mean, I guess setting aside the settlement agreement, yes, in my pre-filed testimony, I think that one of two adjustments could be made. The cost of equity estimate must be adjusted lower from whatever you start out with at the CAPM level. It would really need to be adjusted to basically make SPS's capital structure, under the modeling anyway, equal to the proxy group average. And by doing that, you would get a 7.9% cost of equity. So let's say in some other alternate reality that happened and the ROE was 7.9%, then I don't think any capital structure adjustment would need to be made under that scenario. So it's either or, really, the lower cost of equity estimate or the capital structure adjustment.
But the actual agreed upon cap structure and ROE that were accepted in among other things in the stipulation were different than what you recommended, correct?
Yes, I understand the settlement adopted the company's proposed capital structure. So there's a big difference than what I had recommended in my pre-filed testimony.
And are you comfortable then? I mean, I realize you're not the stipulation witness, but are you comfortable with that?
Well, I don't have any reason to say that the settlement is not fair. For one, I didn't participate in any of the negotiations, but even if I had, my understanding of how settlements usually go is there's a lot of give and take on other issues. And a lot of those other issues I didn't look at in this case, and many of them I'm not holding myself out to be an expert on. So with all of the parties, and it's pretty common, settlements are pretty common where everybody gets together, all the issues are on the table, and there's some give and take and negotiations, and then the signatories to that settlement are indicating that it is a fair deal for the parties that they represent. So I'm not in a position to say I'm uncomfortable with that for some reason, because I wouldn't have a basis for doing that, really.
Okay. Very well, sir. Thank you. I believe that Commissioner Ellison had some questions for you. Commissioner?
Hi, Mr. Garrett. Good afternoon.
Good afternoon.
I did want to go over a few things regarding your testimony and, really the direct testimony in thinking about the initial proposal and your analysis. One thing that Ms. Martin from Excel brought up was the difference between regulatory versus economic capital structure. Her argument was that the rating agencies would calculate a different percentage of debt because they would look at off balance sheet transactions such as lease agreements. Are you familiar with this particular distinction?
On that specific distinction, I didn't rebut that in my testimony. And so I don't have a reason to say that she's not right about that specific issue.
Wouldn't other operating companies, electric operating companies, have the same issue where they would have one approved regulatory capital structure, and the rating companies may calculate something different?
Well, if I understand your question, I think that would be right if you're asking if it would apply to other companies in the same way that she's describing.
Right. And when you look at a list of the operating companies with the range of debt, that would all be reflective of the regulatory approved capital structure. Is that correct?
I think if you're talking about this, we're talking about kind of the same data source. I suppose there could be situations in which for some of these utilities, where the operating subsidiary did have a different capital structure that was approved by their commission. I think most of the data that I look at is just the operating company's actual capital structure. I mean, you could have you'd have a different data source, I suppose, for the capital structures that are approved by the commission. Oftentimes regulators do approve the actual, which is often the proposed capital structure of the regulated subsidiary.
Well, it may be helpful to look at that particular appendix that I believe Mr. D'Ascendis had that in his testimony regarding the capital structure. Hearing examiner Hurst, would you happen to have that available? The testimony of the direct testimony of Mr. D'Ascendis and that particular appendix?
Yes, sir. I'll pull that up. I believe, sir, you're referring to SPS Exhibit 16, the direct testimony of Mr. D'Ascendis.
Yes.
And which attachment did you want, sir?
Well, let's see. There was one schedule that had the different operating companies' debt levels. And I'm going to struggle to find it very quickly. Let's see.
Maybe 2.5.
Schedule 2, page 5. Yes.
I was almost there. I had schedule 2, page 3. There you are. Can you see it?
Right. Yes, thank you. So if we look at the equity here of these operating companies, it's got at the bottom Southwestern Public Service at 54.46%, which is pretty close to what SPS is asking for now. Is that right?
Yes, I believe that is right. Maybe just a slight difference on the timing for when from the rate case filing to whenever this data was compiled. But yes, they're pretty much the same.
And so these numbers from about 51 to 58%, would you think that they, I guess these are reported by S&P, are reflective of the approved capital structure, or is it just hard to say what they may have done here?
I think generally, probably it is going to be reflective of the approved capital structures. Again, for the source of this data, I don't know if he's meaning to show the authorized, but I thought they would just be, my understanding was just their actual capital structures that would be reported on the financial statements. In my experience, most regulators approve these types of actual capital structures as the rate capital structure to apply to rate base. So probably these are generally reflective of the approved capital structures as well.
Okay. In any case, it seems that SPS is at kind of the top of the range here. Wouldn't you say, if we're looking at a spread between 41 and about 58% common equity?
Yes, based on this data.
The concern was expressed by Ms. Martin that any reduction from that, 54.7% that is being requested could potentially call the current rating of SPS debt into question. Is that an assertion that you would agree with?
I don't generally agree with the narrative for a few reasons. For one, we're talking about the rate making capital structure that would be applied for purposes of calculating the rate of return, whereas the company's actual capital structures within the discretion of their management. Two, I think it ignores all of the other factors that can influence credit ratings and all the decisions that the company can make. Maybe that type of narrative, and I see it from other utility witnesses too, is if we don't want to change anything else at all, and there's this capital structure adjustment, or if we were to adjust our own capital structures to be reflective of the commission's authorized capital structure, there could be a credit ratings downgrade. In most cases, the utilities would still be above investment grade. It might have a slight impact on the cost of debt going forward, but the way the numbers shake out is it would have a decreasing effect, usually on the overall cost of capital, which I think should be the main focus. So I generally kind of disagree with the narrative. But if she were describing a situation where if nothing else changed and you only move this one factor and you moved it enough, could it have a downward pressure on credit ratings? I suppose it could. I just don't think that's the commission should be the primary focus for the regulator.
Right. And it seems that, the ratings of these subsidiaries aren't mentioned here, but I would imagine that, the overwhelming majority of these have investment grade ratings. So why would you think that, a company in the, low 40s in the equity is able to have an investment grade rating, whereas Southwestern would find it difficult to drop below the 54.7% requested?
Right. I mean, that's a good point. Those are the type of what raises the same kind of suspicion when I'm reading that type of testimony too. I guess to play devil's advocate against myself, I mean, the financial situation for every one of these companies is also different. So you have to kind of look at the whole picture for each company. But just looking at the capital structures, yes, I think that it doesn't help the utilities narrative when there's all these other examples of, lower equity ratios and higher debt ratios, not to mention the proxy group, which is kind of the group I focus on, the holding companies, not the operating subsidiaries, where they're all investment grade too. And of course, they have much higher levels of debt, lower levels of equity in their capital structure. So it's definitely a fair point to make.
Another issue on the ROE calculation, Mr. Diascendis came up with an equity premium, to use in the CAPM or risk premium model of about 9.2%. And if we add this to today's risk-free rate, which, let's just for conversation purposes say is 3.8%, we come up with 13% growth of the market indefinitely. So when I raised this point to Mr. Diascendis, he said, no, we're not calculating growth when we're doing the CAPM. We're calculating returns, which includes dividends. In your view, is this a relevant distinction?
I think on that point, I don't think I would necessarily disagree with him. If based on how you described it, I do strongly disagree with him on his estimate for the equity risk premium. And like you said, if you're adding that to the current yield on treasury bonds, which is widely accepted as a proxy for the risk-free rate, then you're getting an expected return on the market that I think is very high. I mean, the risk-free rate part is not controversial really, but that equity risk premium portion, I very much disagree with him on that number. I think in this case, his estimate was as high as 10.4%. I think he runs various models, maybe with some different equity risk premium estimates, but I think that's very high when you compare it to expert surveys and other sources.
Right. His average, he did get, several different estimates of that equity risk premium, the average of which was 9.17%. And of course, there were some other estimates which were higher. But the 9.2%, I'm going to call it equity risk premium, seems a real outlier when you compare it to, say, Kroll at 6%, or Demoteran, I think, is currently most recent is somewhere around 5.25%. So, I mean, wouldn't you say that Mr. Diascendis's estimate is a real outlier from what most academics and analysts and companies in the field are coming up with.
Yes, I would agree with that. You know, this is a number that can't be directly measured. It is an estimate. But when you look at the other sources, like the ones you mentioned, Kroll, Damodaran, and other expert surveys, and I cite those in my testimony, the kind of the average estimated equity risk premium from those sources is about 5.6%, which is what I use in my CAPM. So that is a very big difference from Mr. Diascendis's opinion about the equity risk premium.
And so when I asked Mr. Diascendis about whether his number, what's wrong with everybody else's estimation, if his estimation is right, one response he gave is that Professor Damodaran consistently underestimates next year's returns, and that Mr. Diascendis felt that the way to calculate CAPM is a summation of annual returns that are discounted. Is that the normal way that you'd perform a CAPM calculation when you're taking into account the long-term equity risk premium?
Well, I don't think so. I mean, based on what you're describing, if Mr. Diascendis is talking kind of about actual returns, those, if you were to see a line on a graph, those go up and down quite a bit. I mean, in 2008, you'd have like a negative 35% return on the S&P 500. But Dr. Damodaran's estimate for the equity risk premium, along with other experts, they can't go up and down, especially that drastically. I guess what I'm trying to say is actual returns on the market are different than the expected or required return on the market, given the level of risk. And that's true in any individual investment too. If you're investing in any type of asset or project, what's the minimum return you're going to want? It's, well, obviously the risk-free rate's your minimum, because you can get that without taking on any risk. So you're going to want 10%. If it's a really risky investment, you're going to want 20, 30, 40, 50. But let's say it doesn't work out and you have some negative return, or it's much less than that. That doesn't mean that your expected return was wrong. It still may have been very right, and it will be the year after that and again, even if you had negative returns forever. That can't be what an expected return is. And the equity risk premium is the expected return on the market. So if Mr. Diascendis is saying, hey, Dr. Damodaran and these other sources, they estimated a equity risk premium of 5.5, but look at the market this year, it was 20%. But those are two different things, because then the market the next year is negative 35, or like last year in 2022, right. Negative 18.
Right.
So, some years that you could kind of point to that and say, hey, look, that they can't be right. But then it kind of balances out, I think, in the long run. And anyway.
I guess what, you could say that, you could just forecast yearly returns going out indefinitely, and then discount each year's return by the discount rate, and then add them up to get, sort of returns going out to the future. But, that's certainly not what the CAPM does, is it? It takes a equity risk premium, multiplies it by a beta, and then you add the risk-free rate. So it's really two very different ideas, isn't it?
Well, in some ways, but the first part of the process you were describing, that is kind of one way to estimate the equity risk premium. You're basically doing a discounted cash flow model on the entire market, which is usually people use the S&P 500 because it's enough of a sample size. But so you're growing, and I present that model. This is a model that Dr. DeMotoran promotes. And so that's where I learned this particular way of estimating the equity risk premium from his courses. But you're basically, and you need to consider dividends and buybacks too, but kind of the gross cash yield of the market. And you have to grow that out to infinity, really, just like you would at some point. You need to have a terminal growth rate, and then discount it back. The implied discount rate back to the present value is an implied equity risk premium of the market. So that method that makes sense to me for calculating the equity risk premium. But maybe as to getting back to your question, yes, the CAPM is just kind of measuring something else, but it needs that equity risk premium component to plug into the model. So we need to get that from somewhere, can calculate it like I kind of described yourself. You can rely on these other sources. I'm sure they're taking somewhat similar approaches, the expert surveys. But when I went through that process in my testimony, I came up with 5.7%, which is very close to the expert survey, the average expert survey response of 5.6, pretty close to DeMotoran's at 5.1. He does, changes every month for him, and he has different variations that he does. But so that gives me some confidence that the way I applied the model is reasonable. But you're right. Then the CAPM is kind of measuring something else. You're really now saying we need to see how market risk is going to impact an individual firm, because now we want to invest in one company, not just the whole market. If we want to invest in the whole market, we don't need to go to the next step of the CAPM. You already have your risk-free rate and your equity risk premium. You can kind of see what your expected return if you bought the S&P 500 is. But now we want to see for one firm. Well, we have to see how market risk impacts that one firm, and that we do through the beta term of the CAPM.
Right. I guess there can be multiple ways of calculating that equity risk premium. Yeah, I guess what I was getting at is, wouldn't you think it'd be very hard to guess what next year's market return is, and then 2025's market return? To nail a forecast on market returns for 2024 or 2025, that's sort of, a fool's game, isn't it, to try to guess exactly what the market is going to do in any given year. It seems like there have to be equity risk premium estimation techniques that don't rely on that.
Yeah, that's an interesting point. All of this is, you're trying to estimate something that can't exactly be measured, so we have to do something. But any model is inherently going to be flawed potentially, because we're not measuring something that can be directly calculated. So we're going to have to make some predictions and estimates. In this case, kind of assuming applying a growth rate to the cash yield from the market, or the dividend, so to speak, from the market, the total dividend, total return, and discounting it back. It's one way to try to estimate the equity risk premium, which I don't know exactly how Kroll does it, or all the thousands of different expert survey respondents. Who knows where they're getting their estimate from? But when you see enough sources like that kind of pointing to something closer to 5.6%, I feel pretty comfortable using that in my CAPM model, certainly much more than a 9.5 or 10.5%.
Okay, that's helpful. When Mr. Diascendis calculated his cost of equity estimation, he took 4 different methods, took the lowest number, which was his dividend discount model result, and averaged it with his highest number and got the 10.85% number, and then applied a range of plus or minus 50 basis points to it. So why not simply use the range of, I think it was 8.7 something to 12 point something. Why do this step of averaging the highest and lowest and then having a 50 basis point, or I guess a 100 basis point range around that?
I can't speak to why he would have done that. Maybe he specifically outlines that thought process in his testimony. I think the other way that you're describing could be reasonable too. I mean, and probably, I know I sometimes have to think about that when presenting a recommendation. Are you going to present a range? And then, I imagine every cost of capital witness, has kind of their own way of doing it and has to think about that. But so I'm not sure exactly why he chose to specifically do it like that in this case.
It doesn't a range generally indicate your level of confidence in an estimation? So a tighter range would generally indicate a higher level of confidence, and a larger range would indicate a lower level of confidence.
Maybe if you're talking about a range and the results of one of your models, but I would caveat that saying, in this case, I have a large range, 7.9 to 8.7%, but it has nothing to do with confidence. That range is driven by the discrepancy between SPS's proposed equity ratio and the average equity ratio of the proxy group. I'm very confident in my CAPM results of 8.7, but now I've got to adjust it down to 7.9 to account for the fact that SPS has less financial risk than the proxy group. So now my range is 7.9 to 8.7, but without that big capital structure discrepancy, I think I would have had a tighter range. And then sometimes the DCF can produce different results than the CAPM depending on the time. I think the CAPM is just the superior model and probably should be the primary focus. But in this case, I ran a version of the DCF using a sustainable growth rate that, interestingly enough, did produce a 7.9%, which is the same cost of equity indicated under the capital structures proxy group. I mean, capital structures, the proxy group's capital structure, but that's more coincidental. So I kind of see what you're saying with the tighter range, but I don't know if it has much to do with confidence, because given what's happening in the market at any given time, the discrepancy between the DCF and the CAPM could be a lot. Like back when we had historically low interest rates, we're getting very low CAPM results. Sometimes the first number would be a 6 for my CAPM, 6 point something. But then the DCF, which has issues, I think, of feedback loop issues and things like that, it may have been in the high 8s. So there's this 200 basis point difference. But I'm very confident about the results of each one of those models that I ran. It's just the market's kind of causing this discrepancy.
I guess the point I'm making here is that my understanding is that you really looked at these two different models, the dividend discount model and the CAPM model, and that sort of the results from those two different models formed your range. With Mr. D'Ascendis, he sort of had a natural range of 8.7 to 12 point whatever, because he used essentially 4 different methods and kind of averaging it and then saying, let's do this arbitrary 50 basis points on either side of it. I just wonder, what the justification might be other than the desire to make it seem like there's more confidence than you're actually getting.
Yeah, I like the 8.7 part of his range. I think that's pretty indicative of a good cost of equity estimate. But yeah, I mean, I've never seen a utility witness propose a range with the bottom end of the range ever being that low. As far as why they decide to do that or not, that we'd have to ask them. But so I'm not sure, why he chose to do that, but I don't think it would have been unreasonable. But then, of course, I think the top of his range is very unreasonable for, some of the reasons discussed in my testimony. But so who knows?
Right. Also, Mr. Diascendis made the following sort of statement about the DCF or, dividend discount model, that it has consistently been lower than the awarded returns, so it shouldn't really be given that much weight.
Yeah.
But on the other hand, isn't the whole purpose of doing these models because there are concerns around whether the awarded ROEs are reflective of the true cost of capital?
Yeah, the second part of your question is what I was basically going to say. Utility witnesses inevitably are going to come back to an average of awarded ROEs. They might have 1 million pages of analysis, but the impression I get, they really would just like the status quo to just kind of keep continuing. So they'll kind of point to an average around the country, and then it's either we're getting in a feedback loop again. If you say, well, we can't rely on the DCF because it's lower than the average awarded, I mean, then that defeats the purpose of why are we even doing this analysis? Just go grab the recent reports and just plug in an average if that's what you want to do. But you're right. Now, I have the opinion that, and I described in my testimony, that awarded ROEs are consistently higher and have been for many years than cost of equity estimates at that time. And I do that by, well, like we just talked about earlier, adding the risk-free rate to the equity risk premium. You do that for the estimates each year. And I get that it's an opinion, but there's such a big gap between awarded ROEs and, I would say, market-based cost of equity estimate. I think it's pretty easy to conclude that they're generally higher. So, hey, if you're a shareholder, yeah, you want that to keep going. I mean, I would too, as a shareholder.
This is in your figure 5, I believe, of your testimony, that you have that graph.
Right. Right. And this is based on, Dr. Damodaran. I like using his data because it's publicly available, so all the parties can access it. But it's just adding treasury bond yields for each year to his estimate of the equity risk premium, which we see isn't too far out of line. In this particular case, there's a kind of a gap between him and Kroll, but Kroll, I don't have a subscription to. It's a little bit of an outdated estimate now, and then every once in a while they'll kind of, at least for the public, kind of update their estimate of that. But so even if you think the world's leading expert on it is wrong and he's kind of a little bit low in his estimates, I mean, still, it's like that dotted line isn't going to move up that much. Certainly not enough to cover, the authorized ROE line. And we haven't even talked about beta yet. Once you bring in the fact that betas for utilities are lower than 1, utility cost of equity is lower than that dotted line. So it's a little bit of a problem. I mean, I guess I don't know. Just you can buy utility stocks. If you can't beat them, just join them. But I think it's an economic issue. And but even regardless of all that, we can't change anything that's happened in the past. I just try to focus, commissions on really focusing on market-based cost of equity, not an average. What did Mississippi just do? What did Texas just do? It really doesn't. It shouldn't matter. And if that does matter, you don't need the thousands of pages of testimony from all these, ROE experts. So I think it's
and-
better. This is a better approach.
And so what are some of the factors that might cause approved ROEs to exceed the true cost of equity?
Well, one, I think, well, since you asked me under oath, I got to say, probably baked in that figure are some settlements, which might not be indicative of market-based equity costs. I'm not making any kind of judgment on the settlement before the commission specifically. And again, I'd just be looking at the ROE component and not all the other issues in the cases. But, and another reason, maybe just the collective power of and influence that Wall Street has just outweighs customers a little bit in the regulatory environment. I mean, there could be many factors at play, but I think it's more of a fact than an opinion as far as what you're seeing in Figure 5, even if you think the dotted line should be a little bit higher. Again, you'd be disagreeing with one of the world's leading experts, but you have a reason for doing that. Okay, maybe it's a little bit higher, but still not enough, not even close to make up for the difference. As far as all the reasons why, I mean, that would be case by case basis over many different years and many different states to really try to get at that. But commissions are maybe generally more persuaded by maybe not to the full extent of the utilities testimony to adopt their recommendation, but when they adjust it down from that, probably not low enough to really get to market-based equity costs.
And when you say the world's leading expert in equity risk premium valuation, who are you referring to?
I'm referring to Dr. Damodaran, and I'd say one of the world's leading experts. I guess I should clarify. I mean, that's just a judgment call.
His cost of equity data over time there that you're displaying
right.
in the chart.
This data he publishes on an annual basis, dating back maybe even before 1990, but I just go back that far. Now he's not publishing the awarded return data. That's from a different data source, of course. But
I understand.
I'm kind of inferring it here, and that's why I'm hesitant to say that Dr. Damodaran is saying this is the market cost of equity, but I am taking his, kind of the year-end treasury bond yields for 30-year, maybe 20-year in that case. I think both are reasonable estimates for the risk-free rate, could be considered. And adding it to his estimate for the equity risk premium. So it's, I think, equates to a reasonable market cost of equity estimate for each one of those years. If we just took Damodaran out of the equation and went back to expert surveys over all that time, I think we'd get a pretty similar line. It wouldn't be materially different or all higher or all lower. I don't think, maybe slightly higher in some years, but so I think if you go to different data sources, we could do one with Kroll, Kroll and formerly Duff and Phelps might be a little bit higher. They tend to be a little higher than Damodaran, but my overall point would still stand, I think. It's just the discrepancy would be a little bit less. The gap would be closed a little bit.
Okay. And, when you're estimating growth rates for, I guess either the dividend discount model or, trying to figure out, the equity risk premium, is it standard to use the Bloomberg and Value Line 3 to 5 year analyst projections?
Oh, and the DCF model?
Yeah, I guess if we talk about the DCF model.
Is it standard? It's standard in regulatory proceedings. A lot of analysts, and I conduct a variation of this myself because regulators obviously are interested in this. So I kind of present it for information purposes. But, and I describe a lot in my testimony about this, I think, but the problem with that is these are short-term earnings growth estimates. I mean, there's several problems with it, but so the commercial analysts from Value Line or whoever they're not saying that earnings are just going to indefinitely grow like that year after year. They might be projecting that over the next few years, they could grow like that at a rate of 5-6%. But it's hard to maintain that type of growth for any company over the long run. And when you think about a utility, really the core of their operations and what's going on, trying to look at more qualitative growth indicators, like where are they growing to? You know, where's all this growth coming from to serve a very modest and sometimes declining customer base? A very modest growth in customers and sometimes declining. So I just don't think it's a great approach. I mean, I think the CAPM superior anyway for other reasons, but if we're going to run the DCF model, we need to be really careful about that terminal growth rate not being too high. I don't think it should exceed US GDP growth,
did you adjust your growth projections downward to take into account that the Bloomberg and Value Line analysts were giving you a 3 to 5 year projected return?
Well, in the variation of the DCF model that I conduct that does include those analyst growth rates, I don't adjust them at all. I just kind of say, this is the type of model that's often presented in these proceedings. And so here, if you run this model, here's the result you get, which I got 9% from that, which I try to clarify, I don't think is a good indication of cost of equity, although in this particular case, it's not that much different than 8.7%, but still conceptually, considering the principle of it, I don't like the result of this model as being indicative of real market-based equity costs, especially compared to the CAPM, which is just much better.
Right.
I don't adjust the growth. I don't adjust the growth rates published by Value Line in this case.
But you acknowledge that they are probably on the high side, given the fact that they are a 3 to 5 year estimate.
Yeah, I think the highest one I show in if you're just looking at earnings growth from Value Line, was a 7% for Evergy. I mean, to grow earnings by 7% in 1 year is really good. But then now that you've grown earnings by 7%, guess what? You have to do it again the next year, starting at the level you just left off at, and again by 7%. To get that kind of compound growth year after year is very difficult. It's effectively impossible over the long run. Although if you say going out too far in the long run doesn't really help us out in our modeling in this case, I guess you could say that. But just mathematically speaking, if you have two runners running a race and one has a head start of 100 miles, if the one that's way behind is running even just a little bit faster, eventually they would catch up, assuming they're both just keep moving. And so in this case, the earnings of some of these companies under the DCF model I show, they will eventually exceed US GDP because the annual earnings growth are higher than US GDP. Now the US GDP is starting at, a much higher level, but eventually that's how the math works out. You might say, well, that's going to take 60 years for that to happen or something. Well, okay, I get that, but we don't have any of these problems with the CAPM. But so I don't like it for that reason.
Okay. Well, that's very helpful, Mr. Garrett. I appreciate that, and I think those are all the questions I have for now.
Okay,
thank you, Commissioner. Mr. Stoffel, do you have any redirect for your witness?
Just a few brief questions, if I may.
Go ahead, sir, please.
Mr. Garrett, when you were having this discussion with hearing examiner Hurst, you indicated that you were not involved in these settlement discussions, correct?
Yes, that's correct.
And based on your experience in rate cases like this one, were you surprised that ROE and capital structure would be part of a negotiated resolution?
No, I wasn't surprised to see that.
And as part of that negotiated resolution, the parties didn't agree on a specific methodology for calculating ROE, did they?
No, I didn't see that in settlement.
And it was just one of a variety of issues that you understand were settled by the parties?
Yes.
And so then in your conversation with Commissioner Ellison, you indicated that settlements could be one reason why approved ROEs might appear higher, or it might exceed market ROEs historically. Do you recall that?
Yes.
And so in that data set that looks at approved ROEs, it wouldn't provide any context for ROEs that were agreed to as part of a settlement, would it?
It wouldn't provide the context. I think if you go back to the data source, they might differentiate from year to year the results of the settled ROEs versus the fully litigated ROEs. But even getting down to that level of detail, there's no way that data would show all that went into coming up with those numbers.
Thank you. I have no further questions for Mr. Garrett.
Thank you. Anyone have any questions based on the redirect, Commissioner Ellison's questions, or my questions for Mr. Garrett? Hearing no other questions, Mr. Garrett, thank you very much for your appearance here today and your excuse, sir.
All right, thank you.
And I believe that it's the pleasure of let me see.
Your Honor, if I may, we had Mr. Higgins queued up to go after lunch before we called
Okay.
to go to Mr. Garrett. If it'd be possible to call Mr. Higgins, we would be
All
great.
right, sir. All right, let's do that.
Your Honor.
Who's speaking?
This is Major Buchanan. Just
Yes,
for
Major.
planning purposes, since Mr. Walters is now going to be called, would that be after Mr. Higgins?
Yes.
Thank you.
Yes, subject to the pleasure of the commissioners. I see that Mr. Walters is queued up, and I believe that possibly he would be called next, depending on the amount of questions. It could be after a brief recess, but I would intend on trying to get Mr. Walters in shortly. Very well.
Yes, thank you.
Okay, thank you. Okay, so here comes Mr. Higgins. Hello there, Mr. Higgins. I see your name, but I don't see you. Mr. Stoffel, does he need to reconnect or?
I'm here, Madam Hearing Examiner.
Oh,
Sorry.
there you are. Okay, I hear you.
I
There you
was-
are.
Yes, I was on YouTube and then scrambling to get back to.
Awesome.
Invite.
Good afternoon, sir.
Good afternoon.
Mr. Lee, would you swear Mr. Higgins in, please?
Mr. Higgins, would you please raise your right hand? You solemnly swear the testimony you're about to give in a matter not pending to be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Go ahead, Mr. Stoffel.
Good afternoon, Mr. Higgins.
Good afternoon.
Will you please state and spell your name for the record?
My name is Kevin C. Higgins, Kevin, middle initial C, Higgins.
By whom are you employed and in what capacity?
I'm a principal in the consulting firm Energy Strategies.
Did you prepare direct testimony and attachments on behalf of the New Mexico Large Customer Group in this proceeding?
Yes, I did.
And a copy of that has been marked as NMLCG Exhibit 1. Do you have that in front of you?
Yes, I do.
Was your direct testimony and attachments created by you or under your direction?
Yes,
Do you have any corrections to your testimony?
I do not.
If I were to ask you the questions in your direct testimony here today, would your answers be the same?
Yes,
Thank you. I move for the admission of NMLCG Exhibit 1, the direct testimony and attachments of Kevin C. Higgins as uploaded to the Dropbox.
Any objection to what's been identified as NMLCG Exhibit 1? Mr. Higgins' direct testimony as verified by him here today, and whose testimony was placed in the Dropbox as NMLCG 1. Hearing no objection, NMLCG 1 is admitted. Mr. Stoffel?
Thank you. Mr. Higgins, did you also prepare stipulation testimony on behalf of the NMLCG in this proceeding?
yes, I did.
And do you have a copy of that that has been marked as NMLCG Exhibit 5?
Yes, I do.
Was this document created by you or under your direction?
Yes,
Do you have any corrections to your stipulation testimony?
I do not.
If I were to ask you the questions in your stipulation testimony here today, would your answers be the same?
Yes,
And you did not have any attachments to your stipulation testimony, correct?
correct.
Thank you. I move for the admission of NMLCG Exhibit 5, the stipulation testimony of Kevin C. Higgins.
5 or 2?
5. We'll cover the others when we move to admit Mr. Bieber's testimony.
Okay. 5. Any objection to what's been identified as NMLCG 5? Mr. Higgins' testimony in support of the contested stipulation as verified by him here today, and as being the version of the testimony placed into Dropbox that is sought to be admitted. Hearing no objection, NMLCG 5 is admitted.
Thank you,
Mr.
Your Honor.
Stoffel?
Mr. Higgins is available for questions.
Excellent, thank you. I guess just let the record reflect that no cross-examination time was requested for Mr. Higgins. But I've got a few questions for you, Mr. Higgins, so I appreciate you being here. And I believe that perhaps one of the commissioners may have questions for you also. And I guess I just want to start out with your direct testimony. And I know that you're here on behalf of the New Mexico Large Customer Group, and you testified that the Large Customer Group is an informal coalition of corporations here in New Mexico, and they operate facilities in SPS service territory. Correct, sir?
Yes,
And are these corporations or businesses that generally take under the SPS large general service transmission rate?
yes.
And do you have any distinguishing characteristics between your client and the types of customers who take, for example, like FES or LES and FEA?
Well, I would say that from the standpoint of the end use that the customers put their power to, the members of the large customer group are certainly different from the federal executive agencies, which I imagine are essentially taking service for defense facilities. whereas the NMLCG group is primarily loads associated with oil and gas or refining.
How, for example, then would the interest differ between those two groups?
Well,
For example, in negotiating, I guess.
Sure. Well, I don't purport to know what a particular strategy other customer groups might have. Obviously, I can read their testimony and participate in a negotiation discussion, but different entities come into a case like this with their own history and their own desires for setting just and reasonable rates. And so I do think it's fair to say that there is a fair amount of commonality among the interests of customers who are on the LGST rate, but they also might have some particular differences. And I think you've seen some of that yourself, Madam Hearing Examiner, in the last rate case, where different parties who were all members of the large general service transmission group had somewhat different perspectives, at least going in, on what a proper standby rate should look like for behind the meter generation. And so I think that particular case illustrates that customer groups who might have a significant commonality of interest still nevertheless have some distinct interests with respect to each other.
And you have a standby rate now, don't you?
Yes, we do, and I am very pleased to see that has happened. That was quite a lot of effort, and I do believe that a rate that is in the public interest was adopted.
But I don't think I saw you at the stipulation hearing.
Yes, I was a witness in the stipulation.
Oh, okay. So your area of assignment in this case primarily had to do with the revenue requirement, didn't it?
Yes.
And I think, as we know, at the beginning of the case, SPS asked for a increase of approximately $76 million. Excuse me. And that
Yes.
sort of got winnowed down, I think, by rebuttal case to about 75.
Yes.
Is that correct? But after you looked at it and made the adjustments that you thought were appropriate, you actually recommended just shy of $1 million revenue increase, didn't you?
That is correct.
And I guess I'm just sort of wondering, a $1 million increase and a $33 million revenue increase seem kind of far apart to me, aren't they?
They are.
But yet you filed testimony supporting the stipulation, correct?
That is correct.
So can you just, for the record, of the adjustments that you recommended, along with your colleagues who filed testimony about what they thought should be changed, what gives you comfort in the stipulation that you achieved, or what was achieved by virtue of stipulating in this case?
I'd be happy to do that. If one were to take all of the adjustments I recommended in my direct testimony and reapply them, except insert a return on equity of 9.5%, which was the stipulated return, and use SPS's capital structure, which was the stipulated capital structure. Then the revenue requirement that would be produced from that, with all of my adjustments, would be an increase of $30.6 million. That is, it's within $2.4 million of the $33 million stipulated increase. So based on that, my conclusion is that given the agreement on return on equity and capital structure, that the resulting revenue requirement increase is consistent with the increase that I was recommending based on my adjustments. It would be very close. And of course, settlement is a compromise. And so to come within $2.4 million of where I would otherwise be, I feel is a reasonable result that I can support.
Well, I don't know if you've had time to listen to any of this, but I had indicated last week to New Mexico Attorney General Witness Crane, when I was looking at what she and the other Attorney General witnesses were trying to accomplish, and looking down at her stipulated testimony, I had made a note that she had done it looked as if they had done pretty well for themselves. So based upon looking at all of the all of the adjustments that I know that you had, and hearing your testimony just now, that you were that close to the actual settlement amount, I think probably you're feeling pretty good then about what you achieved on behalf of your client, aren't you, Mr. Higgins?
I do, Madam Hearing Examiner. I'll note, as I pointed out in my stipulation testimony, that SPS did adopt a few of my adjustments in their rebuttal case, so that took them out of play. And in the settlement agreement, there were others that were expressly adopted. And when all was said and done, we wound up with a number that was very close, as I said, to what I would recommend given the ROE and capital structure.
In looking at your stipulation testimony, for purposes of the record, can you explain how the unspecified adjustment works in the mind of one of the settlement participants?
Sure, I'd be happy to do that. Would it help if I did it perhaps by example?
Sure.
Okay, so perhaps we can turn to table KCH1 in my direct testimony, which is where I listed my recommended adjustments. That's on page 15 of my direct testimony.
Okay, just let me get there. All right, sir.
Great. So if you look at some of these various items, we can skip over the first one, which had to do with the allocation factors, but we look at an adjustment called test year plant additions, which is about $3.9 million. That was an adjustment I had recommended based on an estimate I had made of the potential shortfall in the amount of capital investment that would be made by the end of the test period relative to the company's projections. So that was an adjustment I had made that SPS did not agree with. They did not accept it in rebuttal, and it's not called out in the settlement as having been agreed to. So let's just put a placeholder there for a moment. If you look at the next adjustment for the synchronization of rate base and proposed depreciation rates, an amount a little less than $1 million, SPS did accept that in the rebuttal case. So that number was already addressed. There was an adjustment for total depreciation that was not accepted, and those depreciation rates are unchanged from what the company proposed. But then you see a couple of other adjustments, smaller ones for non-qualified pension costs, as well as the annual incentive program. Those are numbers that were neither accepted by the company in rebuttal, nor were included in the settlement agreement expressly. The regulatory asset amortization associated with attachment Z2 charges, that $124,000, that is part of the settlement agreement, and also something that the company accepted in rebuttal. Rate case adjustment was something that was partially accepted by the company in rebuttal and also essentially included.
Yes, sir. Can you start with that line again? Can you start that line again? I'm sorry.
I'm sorry. The rate case expense adjustment is something that was partially accepted in the company's rebuttal, but also included in this stipulation. If you continue down to the NOx allowances adjustment of $1.2 million, that's also in the stipulation. So by enumerating these various items, you can see that there are some items that were expressly addressed and others that were not. So from the standpoint of a party to a case where we are still trying to reach closure on the proper revenue requirement, there are several items that I made adjustments for that SPS simply was not going to be willing to agree to. But they were willing to concede dollars. Now, I'm not alone in that situation. There are other parties with other adjustments that might be similar. That is that the party believes they were legitimate adjustments, just as I do, but perhaps SPS is not willing to concede them as a matter of principle from their standpoint, but still willing to concede revenue requirement in the interest of getting all parties to a satisfactory resolution. So as I was able to say to you, the final number was within $2.4 million of what we would have arrived at using that return on equity and cost of capital and capital structure. The sort of the balance in essence is us conceding a portion of what is unspecified. And in a way, getting to $33 million is also the company conceding a portion of what is unspecified. And so that's really what is in that $8 million. It's the various, it's an amalgamation of proposals that other parties have made, including a large customer group that helped the parties reach resolution on a revenue requirement, but without any party having to commit to the specifics of that adjustment. I hope that is helpful in answering your question.
And I think that elaborates on the concept of the what the parties refer to in Section 1, agreement as to base rate increase of the stipulation at item 12, where the signatories agreed to the unspecified adjustment of $8,675,546.
Correct.
I also wanted your opinion on section 19. Can you see section 19, Mr. Higgins?
Yes, I can.
Okay. And that's the rate design and tariff issues. And there are some agreements in here. For example, at A, where SPS has agreed to collaborate with parties and staff to develop interruptible rate proposals and or demand response product so they can potentially be filed in the next rate case. And then also in B, SPS agreed to a process with regard to the development of time of use fuel and base rates. You see those?
Yes, I do.
Are you confident in the processes set forth in the stipulation that there's enough direction to have those processes go forward productively? Or do you believe that further direction is necessary?
I believe that the stipulation adequately provides the framework for moving forward productively. I also believe that many of the parties in this case were parties to the standby proceeding and were able to work through a challenging set of questions as part of that process. So my expectation would be that parties could build upon that momentum and have a productive collaborative. I'll note that the pursuit of these issues was not something in my direct testimony, although I acknowledge their importance and believe it's worthwhile exploring these issues. But certainly the parties that did advance these objectives were, obviously apparently satisfied that the stipulation provides a necessary framework for moving forward, and I concur with that.
And you think that could happen in the first instance and not to have two processes?
I would be hopeful that we could. But of course,
Very,
it does remain to be seen, of course.
but we're going to be ever hopeful.
Yes, well, sometimes when we do have a success in something that is within our memory, it can give us some hope about being successful again.
I like that qualification of within our memory. I guess it's okay unless we forget. I thank you, Mr. Higgins. Those are the questions that I had for you with regard to your testimony. Appreciate you being here. Stop that. And Mr. Chairman, you had questions for Mr. Higgins, sir?
Yes, thank you. Good afternoon, Mr. Higgins.
Good afternoon, Mr. Chairman.
So I just wanted to go quickly to your direct testimony, page 46.
Yes.
So you're one of the few witnesses that addressed these NOx allowance costs in direct testimony and going forward. And so just a question I've had, especially for the larger customers, in your work on that issue, did you attempt to quantify how much of an increase in coal dispatch cost will come with purchasing NOx allowances?
I didn't forecast what it would be for the future, but part of my adjustment in this case addressed the overage, if you will, that SPS experienced in 2022 and 2023 with its NOx expenses relative to the cap that had been in place. And for that 2-year period, the combined revenue requirement associated with exceeding the cap was about $1.2 million for New Mexico. So on an annualized basis, in the ballpark of about $600,000. That was the amount of my adjustment to, because SPS did seek recovery of those excess expenses for 2022 and 2023. And I recommended disallowance in the settlement, but concurred with that. But in terms of order of magnitude, that's the amount of money that was reflective of actuals in the past 2 years. Whether that number will be representative of future years, I don't know, but I wouldn't expect a huge order of magnitude change. It could happen, but it would surprise me.
Well, you've distinguished yourself by actually having a number, so good for you. Then next question, again, for large customers, my experience is predictability on bills is a issue that they pay attention to. And so sticking these allowances in an adjustment clause strikes me as asking for less predictability in bills. So I was wondering, the support of putting them in the fuel clause, was that a consideration, what that does to volatility of the overall cost and what it does to customer bills going forward?
Thank you for asking that. As a general proposition, I tend to push back against expanding the number of items that are eligible for inclusion in a fuel adjustment clause. However, you may have noted in my direct testimony, I did not object to including the NOx allowances costs on a going forward basis, so long as they were incurred with the interest of keeping overall customer bills as low as possible. That is, if they were incurred for the purpose of controlling costs. And so for that reason, I do not disagree with including the NOx allowances costs going forward. And to your specific question about volatility, the current fuel and purchase power costs in rates today is on the order of $246 million. And that number increased very significant with, over the most recent year. As I just mentioned, the NOx allowances costs that were actuals that in excess of the cap were in the order of magnitude of $600,000 per year. So in the grand scheme of things, when you look at the volatility of fuel costs generally, the NOx allowances costs are a very small component of that total fuel cost. And in my view, would be a small component of the volatility that otherwise does occur with a fuel adjuster in a time when, natural gas prices are volatile and market power prices are volatile.
Again, thank you for that. Congratulations, you're the first witness to have actually analyzed it in dollars. We're about out of witnesses here too, so. And the last question I have on that is, are you familiar with the law that generates the need to buy these allowances? And we've heard from the company witnesses that it's currently stayed by a court proceeding in, I think, Texas was the primary place.
I do not consider myself an expert in the law that requires the purchase of these allowances.
Because my final question is, if these don't matter right now at all anyway, is the issue even ripe for decision? So do you have any point of view on the value of putting something in there, whether it's going to happen or not, or does it really have to be something we're certain is a factor going forward?
I believe in the context of this case, in which the NOx allowances were an issue and the parties have reached an agreement to submit to you, that it is appropriate to keep it in there as is. If it turns out that they are not a cost, then it's a situation of no harm, no foul. And if it turns out that they are a real cost, then if those costs are incurred on behalf of customers to help keep prices lower than they otherwise would be, then I do believe it's appropriate to include in the fuel adjustment.
Yeah, I appreciate your point of view on that. So thank you for your testimony here and adding your expertise to this proceeding. Ms. Hurst, I don't have any further questions.
Thank you, Mr. Chairman. Mr. Stoffel, any redirect for Mr. Higgins based upon my questions or the chairman's questions?
Yes, very briefly, please.
Go ahead, sir.
Mr. Higgins, do you recall the discussion you had with hearing examiner Hurst regarding section 19 of the stipulation on the rate design and tariff issues?
Yes.
And she kind of asked why you might have reason to believe it should work this time better than last time. Do you recall that general concept?
Yes.
Now you worked on that standby issue over several proceedings, didn't you?
Yes, I did.
And during the course of that evolution on that issue, did the management at SPS change?
Yes, it did.
Did you find that had a favorable impact on the discussions between the parties relative to the standby rate?
I did. I found it had an immediate and favorable impact.
Does that give you reason to be optimistic about the commitment made in this stipulation?
Yes, it does.
Thank you. No further questions.
Thank you. Any questions for Mr. Higgins? Nope. All right, Mr. Higgins, thank you. Good to see you again, sir. You are excused.
Thank you very much.
I think now might be a good time. I have 3:15 for us to take our afternoon recess. And I believe that unless, well, let me ask. Mr. Stoffel, anything further from the large customer group?
The last item we have would be stipulating in Mr. Bieber's direct and rebuttal testimony.
Okay, let me just look over things. We'll do that when we come back. I want to make sure there's no questions. And then I would, once we get that complete, if we can go back to if we can go back to LES FEA witness Walters for a few questions when we come back from the recess. So let's come back at 3:30 and we'll recess until then. Thank you. How are we doing, Mr. Lee?
Good, Judge. I'm ready when you are.
All right, excellent. Let's go back from our recess then. And I believe Mr. Stoffel, we needed to stipulate in the testimony of Mr. Bieber. Is that correct?
That is correct. He had direct and rebuttal testimony.
All right, go ahead, sir.
So I would like to move to admit NMLCG Exhibit 2, the direct testimony and attachments of Justin Bieber, and it complies with the requirements for stipulated testimony and is the same version as was uploaded to Dropbox.
Any objection to what's been identified as New Mexico Large Customer Group Exhibit 2, Mr. Bieber's direct testimony as was placed in the Dropbox and which counsel asserts meets the requirements for stipulating the testimony into the record without the necessity of the witness's appearance. Hearing no objections, New Mexico Large Customer Group Exhibit 2 is admitted. Mr. Stoffel?
I would also move to admit NMLCG Exhibit 4, the rebuttal testimony of Justin Bieber, which also complies with the requirements for stipulated testimony and is the same version as was uploaded to Dropbox.
Any objection to what's been identified as New Mexico Large Customer Group Exhibit 4, Mr. Bieber's rebuttal testimony as placed into the Dropbox and as counsel has asserted complies with the requirements for stipulating in the testimony without the necessity of having the witness appear. Hearing no objection, New Mexico Large Customer Group Exhibit 4 is admitted.
Thank you,
Mr.
Your Honor.
Stoffel?
Nothing further from the NMLCG. Thank you.
Thank you very much. And Ms. Drake and Major Buchanan, thank you very much. You have brought your witness, Mr. Walters, to make him available for questions for the commission. His testimony, LES FEA Exhibit 1, has already been admitted. Is that correct?
Yes, Your Honor.
Very well. Let me admit him. All right, Mr. Walters, I see you have joined us.
Good afternoon. Can everybody hear me?
I can hear you. Good afternoon. Thank you, sir. Sorry
for
for
having
any
me.
confusion. Glad that you have time to appear here today. And Mr. Lee, if you would swear the witness, please.
Yes, Your Honor. You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Major? We have your witness. We have your witness sworn in. Do you pass your witness for questions from the commission?
Yes, I do, Your Honor. Thank you.
Very well. Thank you. Mr. Walters, I believe that Commissioner Ellison has some questions for you on your testimony.
Sure.
Hi, Mr. Walters. Good afternoon.
Good afternoon. Nice to meet you.
Thank you. Pleasure to see you. Thanks for being here. I just had a few questions about your testimony. You had come up with a range of an ROE range between 8.8 and 10%, with 9.4% is the midpoint. Is that correct?
That is correct, sir.
And I believe you also stated that should the commission agree with the requested equity ratio of 54.7%, that an ROE in the lower part of that range would be warranted. Is that correct?
Yes, that was my testimony.
How do you feel about the settlement, given that is 9.5% higher than you would have liked to see?
Not to beat a dead horse, but as you've heard time and again, we're here because of a settlement that's comprehensive and the result of give and take by many of the parties. While it is above the midpoint of my recommended range, it is certainly still within my range, even though the settlement's adopting the requested equity ratio of 54.7%. It's still, the result of comprehensive negotiations and give and take by many of the parties in the signatories to this case. So given that it's the result of those kind of negotiations, I'm fairly comfortable and confident in it.
I see. So you're not overly disappointed with that result.
Right.
About the I guess the equity percentage, you have a chart. I'm looking at page 12 of the PDF. I guess that would be let's see, page 7 of your testimony. And could you explain this table?
Sure. So this table is basically, it measures just the average and median reported authorized common equity ratios throughout the United States by year dating back to 2016 for all electric utilities, except for the reported equity ratios for electric utilities in the 4 states listed below or at the bottom of that table, which are Arkansas, Florida, Indiana, and Michigan.
And you state here the reason they were excluded is because they include non-investor capital. Is where else would they receive capital?
Sure, that's a good question. So in most jurisdictions, items such as accumulated deferred income taxes are treated as rate-based offsets. But in these 4 jurisdictions, accumulated deferred income taxes are treated as a zero-cost capital item. So it would inherently bias downward the reported common equity ratio. Especially, a lot of times the ADIT balances or accumulated deferred income taxes, can make up upwards of 20 or so percent of a total capital basis like that.
I see. So in those jurisdictions, they would include this accumulated deferred income tax as equity?
No, it would be zero cost capital is how they would treat it. Like the total balance would be incorporated into the capital structure calculation. And when you assign a cost rate to it to develop the weighted average cost of capital, there would be a 0% figure in there because those accumulated deferred income taxes are, pre-funded by ratepayers in rates. They're just not being remitted to taxing authorities yet. So that's just one of 2 ways that ratepayers get credit for pre-funding those balances.
Okay. And these numbers here they are state commission authorized equity ratios. Is that correct?
Yes, absolutely. And, under column 2, I'll measure the average of those figures. And then on column 3, I measure the median.
As
then-
opposed to SPS witness Martin brought up a distinction between the approved or authorized capital structure and the economic capital structure, with the idea that leases and other off-balance sheet items would, could be treated or are treated by at least the rating agencies as additional debt. But your chart here would not include that effect. It would just be purely focused on what was authorized.
Correct. Yeah, this chart does not account for any adjustments made by the rating agencies to come up with their adjusted debt figures.
And really all of the companies they look at, the operating companies, they would do that kind of adjustment to come up with an adjusted debt.
The rating agencies would, yes, the rating
Yes.
agencies would consider the handful of adjustments or balances that they make to adjust to what they come up with, the adjusted debt ratio that's ultimately included in their credit metric calculations.
Another question is, I know the proxy group that I believe you refer to here in elsewhere in your testimony is that proxy group that Mr. Diascendis put together. Those are primarily holding companies, I understand. So in your view, when you're comparing SPS's equity ratio, would it be better to compare it to peer operating companies or to the holding companies?
Sure, that's a good question. I can appreciate, and in my testimony, I think I try to do a little bit of both, because the holding companies that are ultimately publicly traded, they're what we as ROE witnesses or analysts use to assess the company's cost of equity. So it absolutely makes sense to observe what their book value or their comparable capital structure is relative to the subject company or the utility of the instant proceeding, or SPS in this case. So I try to do a comparative analysis of both, and that's why you see this table CCW2, as well as what's my attachment CCW2. And then elsewhere in my testimony, further down, I kind of do a comparative analysis of the proxy group relative to SPS based on credit ratings and capital structure.
Okay. And so what was your recommended equity ratio for SPS given this information?
Sure, I did not make an explicit adjustment for the equity ratio. I just noted or observed that I believe the cost of equity to be 9.4%, but should the commission adopt the company's requested equity ratio of 54.7, that an adjustment be made to the lower half of my range. But I did not offer an explicit equity ratio.
I see. Okay. I mean, certainly looking at your table, it looks like 51% seems a pretty solid average and median of these other what's been done in a variety of states.
Yeah, as you can see, it's pretty stable in that range of 50% to 52%, whether you're looking at the average or the median over those 7 year period.
Okay. I guess back to the ROE calculations, the 8.8%, could you, I guess 8.8 and 10%, could you describe in a nutshell how those two numbers were calculated?
Sure. So the 8.8%, or the lower end of my recommended range, is based on the various results of my DCF analyses. And I summarize my recommended range. I'm sorry, if you're on PDF page 74 or testimony page 69, I've got a table CCW 12 there where I summarize my results or my recommendation for each of the various analyses. And then the high end of my range would be based on the risk premium method. And then the capital asset pricing model falls, within that range, closer to the midpoint.
Okay. I think that's probably sufficient for my questions at this point.
Thank you, Commissioner.
Great. Thank you, Mr. Walters.
Thank you for your time, sir.
Major, any redirect based on the commissioner's questions?
I do not have any redirect, Your Honor. Thank you.
Very well. Thank you, Mr. Walters. We appreciate your time, sir. You're excused.
Thank you all. Have a good day.
Same to you. I believe that now completes LES, FEA, New Mexico Large Customer Group, and I believe we are to Mr. Barron and COG. I would just also like to qualify while we're waiting for the witness that I thought perhaps we might get to Walmart today. I don't know. I think some additional time to consider Mr. Chris's testimony is in order, and I'm going to defer any decision on whether or not Mr. Chris's testimony can be stipulated, or that we need to hear and have him present until tomorrow morning. And if we finish the questions for Mr. Barron, I believe since we've completed Sierra Club, we'll decide Walmart in the morning, that we can go ahead and start hearing from staff witnesses. Here's Mr. Barron. Okay. Let me come out of there. Very well. Hello there, Mr. Barron. Good afternoon, sir.
You're on mute, Mr. Barron.
I apologize, Madam Hearing Examiner. Can you hear me now?
I can hear you now. I hate it when I do that.
Well,
good afternoon.
Good afternoon.
Mr. Lee, would you swear in Mr. Barron, please?
Yes, Your Honor. Mr. Barron, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter not bending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Go ahead. Mr. Moffett?
Good afternoon, Mr. Barron. Can you state your full name for the record, please?
Yes, Stephen Barron, Stephen, middle initial J, Barron, Baron.
And can you tell us who you are employed by and in what capacity?
I'm employed by J. Kennedy and Associates, Inc., and I'm president of the firm.
And did you prepare testimony in this case on behalf of COG Operating?
Yes, I did.
And that was direct testimony, rebuttal testimony, and testimony in support of the contested comprehensive stipulation?
That's correct.
Do you have in front of you what's been marked as COG Exhibit 1?
I do.
Can you tell us what that is?
That is my direct testimony and attachments.
And you have 3 attachments to that, right?
That is correct.
Was this testimony and those attachments prepared by you and under your direct supervision or control?
Yes, it was.
And if I were to ask you the same questions today as those questions in your direct testimony, would your answers be the same?
Yes, they would.
Is your testimony and those attachments true and accurate to the best of your knowledge?
Yes, it is.
Madam Hearing Examiner, I represent that COG Exhibit 1 is the same version of the testimony that was uploaded to the Dropbox. And with that, I move the admission of COG Exhibit 1, which is Mr. Barron's direct testimony.
Any objection to what's been identified by Mr. Barron as his direct testimony filed in the Dropbox in this case? Hearing no objection, COG Exhibit 1 is admitted. Mr. Moffett?
Thank you, Madam Hearing Examiner. Mr. Barron, do you have COG Exhibit 2 in front of you?
Yes, I do.
Can you identify what that is?
Yes, that's my rebuttal testimony in this proceeding.
Are there any attachments to that testimony?
No.
Was this testimony prepared by you or under your direct supervision or control?
Yes, it was.
And if I were to ask you the same questions today as those questions in your rebuttal testimony, would your answers be the same?
Yes, they would.
Is your testimony true and accurate to the best of your knowledge?
Yes, it is.
And again, Madam Hearing Examiner, I represent that COG Exhibit 2 is the same version of the testimony that was uploaded to the Dropbox. And with that, I move the admission of COG Exhibit 2.
Any objection to what's been identified by Mr. Barron as his rebuttal testimony and placed in the Dropbox as COG Exhibit 2, Mr. Barron's rebuttal testimony? Hearing no objection, COG Exhibit 2 is admitted. Mr. Moffett?
Thank you. And Mr. Barron, do you have a COG Exhibit 3 also before you?
Yes, I do.
And can you tell us what that is?
Yes, that's my testimony in support of the contested comprehensive stipulation.
Any attachments to that exhibit?
No.
And was this testimony prepared by you or under your direct supervision or control?
Yes, it was.
And if I were to ask you the same questions today as those questions in your testimony in support of the stipulation, would your answers be the same?
Yes, they would.
Is your testimony true and accurate to the best of your knowledge?
Yes, it is.
And again, I represent, Madam Hearing Examiner, that COG Exhibit 3 is the same version of the testimony in support of the stipulation that was uploaded to the Dropbox. And with that, I move the admission of COG Exhibit 3.
Any objection to what's been identified by Mr. Barron as his testimony in support of the contested stipulation, identified as COG Exhibit 3 and placed in the Dropbox? Hearing no objection to COG Exhibit 3, COG Exhibit 3 is admitted. Mr. Moffett?
Thank you, Madam Hearing Examiner. I don't believe any party scheduled any cross-examination for Mr. Barron.
So COG tenders Mr. Barron for examination by the hearing examiner and any commissioners.
Thank you. Good afternoon, Mr. Barron. I've got a few questions for you. I guess I
Sure.
just want to start out understanding exactly what type of interest that you represent. I know in your testimony, you indicate that you're testifying on behalf of COG Operating LLC, and you've indicated that COG takes service at multiple locations in the SPS service area on a primary general service, although there are a few secondary general service rate schedules. That's correct?
Yes, COG Operating is a wholly owned subsidiary of ConocoPhillips, and but the operation of COG it operates oil and gas production facilities and takes service under Schedule PGS, and these facilities there are really hundreds of accounts on PGS.
And
And a few accounts on SGS, just very small.
okay. And generally, your testimony encompasses the cost of service study, the revenue increase to the rate classes, or what's referred to as the rate spread, and then also the actual design of the PGS rate, correct?
That is correct.
And in that particular testimony, even though that you might have a different rate class that you represent from the large general service transmission rate customers, some of the issues that have been brought up in this case are similar, aren't they?
Some of the issues are similar. It is important to understand that because of large cost of service result differences between rate schedule PGS and LGST, the issues in this case as litigated were not the same. Certainly PGS represents larger customers, but they're not as large as LGST. And so there are differences. PGS is on average represents higher load factor customers. So there are similarities with respect to the issues that I addressed with respect to cost of service and based on the reading the testimony of the case, some rate design issues.
And when you say higher load customers, you don't mean equivalent to an LGST customer, do you?
No, and I apologize if I misspoke. Higher load factor customers, meaning that customers on PGS tend to use, for every kilowatt of demand, they're going to be operating at a higher number of hours during the year. So their energy use relative to demand is going to be high. And that's a characteristic of LGST as well, though LGST, I suspect, has much higher load factor or energy intensity, because PGS is comprised of a large variety of customers.
And I guess what I was looking at first, and just in looking at some of the issues that you had in your direct testimony, you're testifying with regard to the way that Hale and Sagamore wind facilities costs are classified. You believed that since they were classified as energy only and that there wasn't a demand component, that your clients were in fact being overcharged and subsidizing other classes.
That is a true statement, but the entirety of my testimony basically discusses the fact that under the company's cost of service study, which classified the Hale and Sagamore plants as 100% energy, even under the company study, there are huge multi-million dollar subsidies or excess charges relative to cost that PGS is paying. What I concluded was if this cost of service study the company study were revised so that Hale and Sagamore were classified as demand, those subsidies would be even greater. But the subsidies, millions of dollars of subsidies still exist under the company's energy only classification for Hale and Sagamore.
And that was part of your alternative cost of service study?
Yes, I did prepare a cost study where Hale and Sagamore were classified as demand and presented the results. But ultimately, in my direct testimony, I accepted the company's cost study and revenue apportionment or rate spread because it did address the large subsidy issue that PGS has been facing for really many years.
And how the rate was designed and especially as it dealt with renewable energy and specifically wind was also an issue that some of the other parties in the case also opined on, wasn't it?
Are you referring to the cost classification of the wind projects? Yes. I believe all of the parties representing LGST customers made adjustments in the cost study to do that, and they presented results based on that cost study. I think the difference is that in my testimony, I presented that, but I basically accepted the company's cost study, and mainly because under a 50% minimum, 150% maximum, that was going to really be the trigger, rather than in the case of PGS, the cost study itself.
And under Want to look at table 7.
Yes, I'm familiar with this.
Okay. And this is entitled Alternative PGS Rate Design Reflecting Uniform Percentage Increases in Demand and Energy Charges.
Yes.
How does this compare with the stipulation increase as accepted?
I'm sorry. We're finished. I'm sorry.
Yeah.
Okay.
Yes, sir.
The stipulation in the rate design for PGS did, and I think you can see it in Mr. Berger's attachment WLB Stip 1, page 2 of 4. The primary general non-fuel energy charge increased is about 13.4%. And so relative, and the demand charges are increasing by about 1.8%. So we don't have equality, but as part of the settlement, and as you've heard many times, the give and take, the assessment of the costs and benefits and the impact of various issues, COG and I recommended, based on my evaluation, that the results of the stipulation were favorable. Just to put it in perspective, and reasonable, because they reflect to put it in perspective, the rate design issue it covers non-fuel energy charges, and to the extent that a customer on rate PGS has a higher load factor or energy intensity, the higher the energy charge increase relative to the demand charge increase would be detrimental. But the impact of that paled by comparison to obtaining a reasonable rate spread that reflects the cost of service results, subject to the gradualism provision of 50% minimum, 150% maximum. And so overall, in evaluating the stipulation and looking at the various components, the stipulation is very reasonable, and certainly we support it.
And as a matter of fact, when you're just looking at page 1 of Exhibit A to the stipulation, of the increases for non-fuel, primary and secondary got the lowest percentage increase, didn't they?
Yes, and that's exactly really what I was saying. Based on all of the cost of service studies filed in this case, all the evidence, PGS and HGS were paying significantly above cost of service by a large degree. And based on the analysis, again, of really all the parties, on a cost of service basis, it showed that the increases that SGS and PGS should get, even under the company's $75 million rebuttal revenue requirement, would be relatively low. Given, and then when you apply at the 50% minimum, which is really reflective of the result you're looking at, the 54%, it's sort of a composite of the various parties' positions in this case, but all of those positions really showed results on this lower end for PGS and SGS.
And while not as low as you would have proposed in your direct testimony, the percentage increase and the amount allocated of the increase reflect, would you say, a significant decrease from the SPS original proposal?
Yes, and that is due clearly to the reduction in the overall revenue increase from 75 million to 33 million. But if you look at Mr. Berger's rebuttal testimony that supports a revenue apportionment or rate spread based on 75 million, PGS and I guess SGS as well are at the 50% level. So it's relatively consistent, and I'm very supportive of both the stipulation and that gradualism construct.
Well, and I don't, since I have the stipulation, I don't have it up here, but I have a note that I believe that if we were looking at an annualized increase from WLB STIP 2, that'd be a 2.41%. Page 2. So that was just showing.
Yes, I'm sorry. Are you talking about the overall PGS revenue increase?
Yes. Yeah, on the whole bill, including fuel.
Oh, okay. I haven't. I don't have that in front of me.
Okay.
Let me wait. I can grab that.
Let's see. I think it's WLB STIP 2. Let me find it.
I was just looking at it earlier today. Okay, I've got it. Yeah, I've apparently. Let me bring it up. I have it on my drive. If you bear with me for a moment. Well, let's see.
It's 76.
Okay, I believe I have it now. I'm sorry.
Okay, so here's WLB STIP 2. What was I looking at? Page 2. That's not gonna help me, is it?
Okay, I think.
STIP 1. Page 2.
The STIP 1 comparisons are these are base rate comparisons,
Okay.
as I understand it.
Okay.
So I think, if I recall, you had asked Mr. Berger to provide an exhibit that
I did.
on the stipulation that would add the full impact, including fuel.
I don't know
Yes,
where where did I get
s-
that?
no, I see it. I see it. PGS summer, it's on, no, if you scroll down a little bit, the next page there. These are, he calculated some typical bill amounts based on different demand levels.
Okay, that's where
but-
I got that. Thank you.
Right, right. And I think this is consistent with the fact that the rate design that we just looked at shows a relatively larger increase, or well, obviously a very large increase on the non-fuel. But these are base rate impacts, but it's consistent with an overall base revenue increase for PGS that's shown on this in the stipulation, I guess, the exhibit A of 3 I guess it was 3.6%, some of that range.
It was 3.76.
3.76, right. So
Mhm.
the class as a whole is receiving a 3.76%
Sure.
revenue increase on base rates. These typical bills were just for some selected load characteristics, but I think in terms of putting in perspective what's going to happen to PGS customers in the entirety, the exhibit A is the best source of that.
Mhm.
And it shows a 3.76% base rate increase.
Right. And I always just, since we try, or at least I try in the notices to put what some don't want to say average. Some utilities like to say the typical customer or whatever. I'm just trying to get the picture out there, of what does this look like, to a broader group, not the high or the low, but sort of the one in the middle. So
Yes, and I haven't done an analysis to determine whether these typical bill calculations. In other words, it shows the first one, a 10,000 kilowatt hour customer and 35 kW, a 3.717% increase, and then goes on for 4 other alternatives. I don't know how, in other words, there's whether obviously a weighted average of these results would not produce 3.76. So there's obviously lots of customers or lots of usage on PGS that would not be represented by this.
mhm.
I assume that. I haven't gone through Mr. Berger's calculations, so I can't. I'm seeing exactly what you see.
Sure. And actually, I pulled, I think, from the information that was in his calculations, and the stipulation, and I actually compared the rates to your rates in table 7. And it looked like to me that that the first 3 rates, well, Yeah, that the first three rates were lower than what you proposed, but the energy charge was a little higher at 0.006624. Your factor was a little higher at 0.83 and minus 0.83, but it looked like you did pretty well on on what you got with what you proposed is just what I was trying to figure out.
Okay.
Do you feel that well? Do you
Well,
feel that way, Mr. Barrett?
I think you have to remember, table 7 was based on the 75 million revenue requirement. So it had, in order to really do an apples to apples comparison, you'd have to make adjustments. But in terms of the energy rate, which is, again, it's non-fuel, so it's a very small piece. It's certainly reasonable, and COG supports it, obviously. I'm talking about the stipulation rate.
Right. And when you say non-fuel, is a small piece of what?
Of the overall charge. It's a relatively smaller piece, but it depends on the customer, what your energy intensity is. Obviously, when you add in fuel, that changes everything.
Well, and I tried to do that for myself. I don't have the answer to the bench request yet, but I looked at Ms. Trammell's it was an attachment to her testimony, and I think the fuel number was $290,030,753. Does that ring a bell?
I don't recall. I know that originally in the company's work papers, they did have the type of analysis that you would ask Mr. Berger to provide. And on the direct testimony of Mr. Luft, and I don't think I calculated on a per kWh basis, but the data is there by rate class.
Okay. I was just trying to make my own column. Let me just ask, because I think basically your stipulation testimony, well, your rebuttal testimony basically is rebutting the position of one of the other interveners. Is that correct?
That's correct.
And yeah, so it's you take issue with Mr. Gorman's allocation of the rate base increases, correct?
Yes, the issue I raised in my rebuttal had to do with the his application of the gradualism adjustment or the mitigation adjustment, and it's somewhat complex, but I tried to explain it in my testimony.
And to me, that just meant what I was seeing was, for example, with how to calculate the correct allocation and cost for, say, like Hale and Sagamore. It seems like to me that different rate class customers could have similar interests, but yet have diverse or opposing interest when it came down to things like how are we going to, how are we going to divvy up this rate increase among the classes, that there could be differences of opinion.
That's exactly correct. That's exactly correct. Because there are two different rate schedules that the customers take service on, the cost of service results under any cost of service method are going to be different, and they're going to imply different revenue increases for any revenue requirement level or revenue increase level. They're going to imply different rate spreads, include and the mitigation, the 50% minimum, 150% maximum plays a role in that, and it plays a big role.
And as you've said here today, you say in your testimony, your stipulation testimony on page 3, beginning on line 11, while the stipulation does not eliminate the rate class subsidies paid by the primary general service customers, it does provide some reduction in the subsidies through the allocation of the lower than average percentage revenue increase to the PGS rate class, while recognizing the important rate making principle of gradualism. Correct,
Yes,
sir?
that's correct, and that's my position in the case, that ideally rates should over time move towards cost of service, but there has to be some reasonable level of mitigation. And I think every party in this case has accepted it, and the stipulation reflects that.
Very well, sir. Those are the questions that I had for you, Mr. Barron, with regard to your testimony. I don't know if don't believe that anyone else had any questions for you. Any redirect, Mr. Moffett, based on my questions?
No, Madam Hearing Examiner, no redirect questions. Thank you.
Don't believe I'm hearing any questions from the commission. So, Mr. Barron, thank you, sir. Appreciate your time. You're excused.
Thank you, Madam Hearing Examiner. I appreciate it.
Thank you. Mr. McMillan, anything? I'm sorry, Mr. Moffett, anything further from COG?
No, Madam Hearing Examiner, nothing further. Thank you.
Thank you. We've already heard from Sierra Club. I've reserved my decision on the Walmart witness until tomorrow. I believe that we probably have time to hear from a staff witness. Mr. Bagatko, do you have a witness, sir?
Madam Hearing Examiner, yes, I do, and that would be Miss Eva Tesoro.
Very well. While we're waiting for Miss Leva Tercero to log on, just for planning purposes, I believe that we'll be able to complete our examination of the remaining witnesses at some point tomorrow. And then we'll come back Wednesday morning at 9 to hear from Dr. Woolridge. I'd like the parties to be thinking about any date that they believe that that they can submit post-hearing briefs and or proposed certifications. I am potentially considering 2 briefing issues that can be discussed later. Good afternoon, Ms. Labor Tercero. I see you have joined us.
Good afternoon.
Mr. Lee, could you please swear the witness?
Yes, Your Honor. Ms. Labor, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, ma'am.
Mr. Pagacco?
Madam Hearing Examiner, yes, thank you. Good afternoon, Ms. Labor Tissero, how are you?
Good afternoon. I'm doing well. How are you?
I am fine. You had 2 sets of pre-filed testimony in this case, correct?
Yes, I did.
One was your direct testimony that was filed on April 21st, 2023. Is that correct?
Correct.
And the other was the testimony you filed in support of the contested comprehensive stipulation on May 26, 2023. Am I correct in that also?
Correct.
Well, I hope you have in front of you what's been provisionally marked as Staff Exhibit 1, your direct testimony from April 20. Got that handy?
Yes, I do.
And that is the same testimony that was uploaded to Dropbox. Is that your understanding?
Yes.
Would you take a moment, Ms. Labor Tissero, and just flip through Staff Exhibit 1 and all of its 123 pages and make sure that it is a edition of what you caused to be filed in this case on April 21st, 2023.
Yes, it is.
And those exhibits that are attached to Staff Exhibit 1, I believe they consist of ELT 1 through ELT 15, correct?
Yes.
And all those exhibits were prepared by you or under your direct supervision. Is that correct?
That's correct.
Now that we've established that it's complete and accurate, I understand you do not have any corrections to make to what we see there in Staff Exhibit 1. Is that correct?
Correct. I do not have any corrections.
Finally, Ms. Labor Tissero, if you were asked the same questions today as what we see posed there in your direct testimony, would answers change that you set forth in that Staff Exhibit 1?
No, my answers would not change.
Well, with that, Madam Hearing Examiner, I would move for the admission into the evidentiary record Ms. Labor Tissero's prepared direct testimony in this case marked as Staff Exhibit 1.
Any objection to what's been identified as, Ms. Labor Tissero, do you still have your YouTube on?
No, I don't believe so.
Okay. Getting some feedback. I'll try again. Any objection to what's been identified as Ms. Labor Tissero's direct testimony, identified as Staff Exhibit 1, verified by her here today, and placed in the Dropbox? Hearing no objection, Staff Exhibit 1 is admitted. Mr. Pagacco?
Madam Hearing Examiner, thank you. Now, Ms. Labor Tissero, if you would follow along with me to the next item, which has been marked as Staff Exhibit 2, and it consists of your testimony in support of the contested comprehensive stipulation. I trust you have a copy of that handy.
Yes, I do.
It's also your understanding that this was what was uploaded to Dropbox.
Correct.
And as we did before, would you please take a moment and flip through your testimony in support of the contested comprehensive stipulation to ensure that it is a complete and accurate rendition of what you caused to be filed in this case on May 26th.
Yes, it is correct.
And this time around, with this testimony in support of the contested comprehensive stipulation, you only have one exhibit, exhibit ELT-S1, is that correct?
That's correct.
And that was also prepared by you or under your direct supervision, I trust.
Yes.
And I understand you do not have many corrections to make to the testimony in support of the contested comprehensive stipulation. Am I correct in that?
That's correct. I do not have any corrections.
And then finally, Ms. Labor Tissero, if you were asked the same questions as what we see posed there in Staff Exhibit 2 today at this hearing, would your answers still be the same, or would you have cause to change any of those?
My answer would be the same.
Thank you very much for that, Ms. Labor Tissero. And with that, Madam Hearing Examiner, I would move for the admission of Staff Exhibit 2 into the evidentiary record, please.
Any objection to what has been identified as Ms. Labor Tercero's testimony in support of the contested stipulation as verified by her here today and placed in the Dropbox? Hearing no objection, staff exhibit 2 is admitted.
Thank you.
Mr.
And with
Bagatko,
that, Madam Hearing Examiner, I would tender Ms. Labor Tercero for any examination by you and or the commissioners, because I do not believe anybody reserved any cross-examination time for her.
and you are correct, Mr. Bagatko. No one reserved any cross-examination time for Ms. Labor Tercero. So again, Ms. Labor Tercero, welcome.
Thank you.
And my understanding of your responsibility as the Economics Bureau Chief in this proceeding that you specifically addressed as set forth in your testimony on page 2 of Staff Exhibit 1. You're addressing proposed class cost allocation, revenue increase distribution, and rate design, other rate and tariff changes, and the proposed electric affordability program, also known as EAP. The company's request for the commission to require SPS to host a collaborative working group and authorize the commission to track and record the workshop as a regulatory
I'm sorry, authorize the commission
asset. To track and record the workshop costs as a regulatory asset. Is that correct?
That's correct.
Ms. Labor Tercero, do you also address all of the regulatory compliance issues, or is that another witness from prior cases?
No, I did not specifically address that in my testimony, but it's my understanding that SPS is in compliance with prior commission orders.
Was that Ms. Stashino?
No, I'm not sure that she did address that.
Did any staff witness address that?
Not that I recall, not specifically, no.
Why not?
I think, we were focusing on the request, but I don't believe that staff had any concerns with that issue. It was staff's understanding that the company was in compliance.
Well, I had that and now I don't have it. It seemed to me that there was an attachment to Ms. Trammell's testimony. It was entitled BAT-3. And this is entitled SPS's prior case commitments. And this is a document that has 28 pages of prior cases. Presumably that SPS was ordered to do something subsequent to the final order in the case. And basically, SPS has filed this asserting that that it's complying with these cases by making these filings. Did you review this? Did you review this attachment, Ms. Labor-Tercero?
Yes, I believe I did in reviewing Ms. Trammell's testimony.
And so can you then now verify that that what SPS has asserted in that particular attachment is in fact in compliance with the requirement of the cases that SPS cited?
To the best of staff's knowledge, SPS is in compliance with the prior commission orders.
Miss Labor-Tercero, do we have a compliance department anymore?
No, we do not, unfortunately.
So how are those things, or are when a case is complete and there's a requirement in that commission final order in that case that something be done subsequently, is there anyone who tracks whether or not that actually gets done?
No, there's not one specific person in the utility division that does that. However, when we work on subsequent cases, we try to go back and look at the prior orders and make sure that the utility is complying with anything that was ordered in a related prior case.
But the commission doesn't actually have somebody that looks at every one of those orders, and if it says something's supposed to get filed within a certain period of time, there's not one person that keeps track of all that.
No, not at this time.
So it is my understanding that after its review of the information presented by SPS, staff was not in agreement with the amount of the revenue increase requested by SPS, was it?
That's correct.
And in fact, staff recommended approximately less than half of what SPS originally had requested, correct?
Correct. Staff's recommended revenue deficiency was about 3.9 million.
And additionally, through other staff witnesses, the return on equity recommendation was also lower than what SPS had originally requested, correct?
That's correct. And I'm sorry, I meant 36.9 million, not 3.9 million.
I was going to say my numbers were written over each other. It was like, yeah, 36,930,982.
Yes,
And staff recommended an ROE of 9.35
that's correct.
with a weighted average cost of capital of 7.07.
Correct.
And the range, I think, for the ROE was 9.24 to 9.66.
That sounds accurate to me, but I would defer to Mr. Tupler on that.
Okay. One of the other issues that you testified, since you're the rate design witness, is that you wanted some adjustments regarding seasonal increases.
Yes, staff recommended some adjustment to the seasonal rate differential. A 20% differential to be specific. I believe the company proposed 15.
And I think on page 24 of your direct testimony, you testified that staff was proposing the seasonal differentials for all customer classes be set at the same rate, 20%, because it's your belief that that differential will send or continue to send customers a clear and consistent signal to manage their consumption during SPS's summer peak. Is that correct?
That's correct, yes. Yes,
Does that apply to an irrigation rate?
well, and I'm going to point you to pull up staff's exhibit. So if you can go to my rate design exhibit, which might be helpful to you. Just give me a second to get there.
Okay, let me come out of the stipulation. Okay. What page would I like to go to?
So this is the exhibit that I'm looking at is exhibit 12. And that has a description of staff's proposed rate design process.
That's ELT 12, and it looks like it's PDF page 93 of staff exhibit 1, correct?
That's correct.
What page of 12?
So it is page, well, what the specific.
All four?
Well, if you're looking at the irrigation, you'd want to go to page 2 of 4. And so the irrigation is there up at the very top.
No, I understand that. So there's no seasonal on irrigation.
Yes, they're actually.
Yes, there is. Yeah,
Yes.
okay.
So this will show you all the areas where that applies.
Okay. Okay. I believe as far as the residential customer charge request, staff was in agreement with the customer charge being requested from SPS.
Yes, that's correct. Staff supported the customer charge of $12.20. As staff believed that continued to be consistent with the commission's longstanding policy of gradualism, but while at the same time moving that charge to cost.
And I know on so their current charge is $9.80 and staff supported the $12.20.
Correct.
And the actual agreed upon charge in the stipulation is if you know.
It's $11.20.
Do you think that still advances the policy behind the customer charge?
I do. I believe that it takes a more gradual approach in moving that cost or that charge toward cost. But I think it's reasonable.
This will be the highest customer charge currently for an IOU, correct?
That is correct. But I mean, as I noted in my testimony, PNM has not had a rate increase since I believe 2016. And in EPE's last rate case, I believe they received a decrease and their charge remained the same.
So you don't believe that it necessarily, there's some aberrant reason why SPS's customer charge is higher than the other IOUs?
I think that, I don't know, I believe that the rates, we should try to move the rates toward cost, and we're still not quite there yet with SPS's charge, but we are making gradual movements in that direction, which I think is a positive.
And with regard to your testimony, on page 39 regarding the EAP or the low income program that was being proposed, staff didn't support it, did they?
No, as proposed, the program would require all customers to pay an electric affordability program or EAP rider to support the rate relief of only certain low-income customers. And in my non-legal opinion and based on commission precedent, I believe that the program as proposed would be discriminatory and contrary to existing law, and specifically 62-8-6.
There were some attempts in the last legislative session to get some authorization for low-income utility rates in New Mexico, Ms. Leyva Tercero?
Yes, that is my understanding, but that legislation did not pass.
Either in the House or the Senate?
I believe that's correct.
Can you confirm whether or not SPS has any program similar to the P&M Good Neighbor Fund that you testified to on page 41 of your testimony?
I believe that I read in Ms. Trammell's testimony that it does have some voluntary programs. I don't know specifically what those are or if they are in the New Mexico jurisdiction.
Ms. Leyva Tercero, in comparing the ranges of the revenue requirement, either decrease or increases, the agreed upon $33 million in the stipulation, would you consider that pretty close to the 36.9 million that staff had recommended?
Yes, I do.
Was that one of the primary considerations in agreeing to the stipulation, that that particular number was close?
Yeah, I believe so. I mean, it, as you've heard, you know, or we've discussed here during the hearing, there is an unspecified adjustment or a black box adjustment. So one could assume that all of staff's adjustments can be included in that unspecified adjustment.
Were there any other, I mean, I know in your testimony in support of the stipulation, I mean, you spend a couple of pages on apparently being pleased that they did withdraw the EAP. And you also testify beginning on page 7 of your testimony, why you support section 15, the collaborative working group.
Yes.
Correct?
Yes.
So Let's talk about my new favorite section, section 15. Section 15 of the stipulation is entitled tolling. It says, the signatories agree to confer and support a motion SPS may file seeking reconsideration of ordering paragraph L of the procedural order, comma, should the hearing examiner condition consideration of the stipulation on an agreement to indefinitely toll the suspension period, comma, in furtherance of a decision by the commission within the current suspension period. That's what that says, right?
Right.
What's it mean?
That, well, that staff and the parties would support a motion that SPS might file in this regard. Because as staff recognizes that there are concerns with timely cost recovery. And I will say if prudently.
I'm sorry, Mr. Labor's concerns
with timely recovery of prudently incurred costs. And
Thank you.
Staff recognizes that that's a concern to be able for the utility to be able to timely recover its costs, and therefore staff would be supportive of such a motion.
Can you name me a case, Ms. Labor Tercero, where the commission indefinitely suspended or tolled a case?
Indefinitely, no.
Well, doesn't this say in this section 15 an indefinite toll of the suspension period? Not what it says?
Yes, it does.
Well, if it's never been done, then why would you agree to include some provision against something that's never been done?
Well, I mean, I would say that the stipulation reflects a compromise and give and take, and this was a concern that was raised, and staff was not opposed to it. I understand it hasn't happened, but I guess that doesn't mean that it couldn't.
There could be a lot of things, Ms. Labor Tercero, that haven't happened that could happen in life, right?
I agree, yes.
And they're not included in this stipulation, are they?
No, I think that what is included in the stipulation reflects the give and take that the stipulation, the concerns raised by the various signatories to the stipulation.
Well, what else in the stipulation should the commission think about that hasn't occurred that parties are trying to guard against if it ever could happen in the future?
I don't know the answer to that.
Well, I really think if the parties are going to agree to some contingency that's never happened before and staff signs on to it, don't you think there should be a pretty good reason?
Well, the staff did not believe that there was any harm in agreeing to this provision of the stipulation.
Well, just for the record, Ms. Labor Tercero, SPS's last rate case number 20-00238 UT, was filed on the 4th of January of 2021. Wasn't it?
Subject to check, yes.
Was suspended on the 13th of January 2021. Correct?
Subject to check.
So technically, 12 months from the suspension period would have an order in that case being due the first part of February in 2022, wouldn't it?
Yes, I believe that's correct.
Wasn't a final order in fact issued in that case on February 2nd of 2022?
I'm subject to check, yes.
So even though there was a stipulation and presumably there could have been some tolling in that case, the final order was still timely issued within the statutory period, wasn't it?
I believe so.
Now, there was a second final order issued in that case after request for reconsideration, I believe by the company and or the parties to the stipulation, that resulted in a second final order being issued in that case on February 16th of 2022. Is that correct?
I'm subject to check, yes.
So was there any indefinite tolling that took place in that case?
No, there was not.
Ms. Labor Tercero, what other the rate design, the overall revenue requirement, the return on equity, are there any other issues set forth in the stipulation that you feel positive about, or that create a foundation for you to support the stipulation?
Yes, for example, the removal of the regulatory assets, which are addressed by staff witness Dashno, that's also a positive.
Was staff, it seems as there might have been other parties, as we've heard, that had issues regarding NOx allowances or retirement dates. How much was there any emphasis by staff on those issues?
I believe, well, I would say, staff in its direct testimony did not propose the retirement dates. With regard to the NOx allowances, staff did address those issues in its direct case. That was staff witness Dashno that might be better able to speak to that. But staff weighed in on all the issues.
In times past, as I understood the structure of staff and staff assignment on cases, there used to be one staff member that was in charge of coordinating the witness team, Ms. Labor Tercero. Is that still the case?
That is still the case, yes.
And is that person the case coordinator?
Yes, you're correct.
And is that you?
Yes.
And as part of being the case coordinator and person in charge, are you the primary negotiator?
No, not necessarily. I would say on my issues that I address, but each staff person is able to negotiate the issues that they address, that they have the expertise on.
Okay.
And we have to be in agreement as a team.
Okay. Very well. I appreciate it, Ms. Labor Tercero. That's all the questions that I had for you. I see that the chair I believe, has some questions for you. Mr. Chair?
Yes, thank you, Ms. Hearing Examiner. Good afternoon, Ms. Leiva Tesoro. How are you?
Good afternoon. I'm doing well. How are you?
Good. So I just had one question, but now I want to follow up on something the hearing examiner just asked you. So I have two questions. Going back to the idea of case coordinator, and then you're saying each member of staff will take an issue and then they have the ability to negotiate that issue in the context of developing a stipulation like the one we have in front of us. We've heard from a lot of parties, other witnesses, that this stipulation is an entire whole and that each paragraph isn't independent of any other paragraph. So is that how staff views this also?
Yes.
Thank you. Just so then, are you the one that glues the whole thing together?
Well, I try to make sure that everything is addressed, and that each of the staff witnesses address the various components of the stipulation that apply to their area of expertise.
Okay. Yeah, so just trying to understand, it's great that people are focusing on their area of expertise, but then when you're bringing something together and presenting it as a whole, if there's any conflict, like one staff member has one thing they don't like, but everybody else is in line with the things they have been looking at, how are those kind of disagreements resolved before staff gets on board?
Yeah, that will be something that, we'll look to make sure, and the team coordinator, the case coordinator will look at to make sure that we are all being consistent and that, that our testimonies flow and that there aren't any disagreements between staff members.
Yeah, I appreciate that. Thank you. Okay, so then to my next question, paragraph 19. So I had a little bit of discussion on that with the hearing examiner, but rate design and tariff issues. One thing I've just been exploring is what the expectation of each of the individual parties of the stipulation have in terms of this obligation to collaborate with. So, we've had quite a few conversations over this week about how there was an apparent gap in a previous settlement. Trying to understand how that gap happened and make sure it doesn't come back on the commission again in the future. So trying to understand from each party's point of view, what do you think collaborate with means? I mean, what is your expectation of SPS if this stipulation is approved?
Well, and it, in my mind, so this means that an agreement could not be reached on this issue, at least in time for the stipulation. So there's more work that needs to be done, and the parties need to discuss the issues and try to resolve the issues and come up with something that is with a time of use, rate design or interruptible rates that are acceptable to all parties involved.
So when SPS reaches out to collaborate with staff, who should they contact?
Well, the only rate design person that we currently have on staff is me, so that would be me.
And then would you prefer an email or a phone call, or I mean, how should that contact happen, and how should the company ensure that communication has been established?
I would imagine that the company would reach out to all parties, and that's likely going to be through an email, and that's fine with staff. To try to get the ball rolling, I imagine that's how they'll reach out.
Would you like your email to be in the final order?
No, thank you.
Well, thank you for the work you do, Ms. Leyva Tercero. I don't have any other further questions, hearing examiner.
Thank you, Chairman.
Thank you, Mr. Chair. Commissioner Ellison, sir, do you have questions for Ms. Leyva Tercero?
Yes, please, just a few.
Please, go ahead, sir.
Hi, Ms. Leyva Tercero, good afternoon.
Good afternoon.
I wanted to ask just a few questions, and you obviously can let me know if there's someone else I should be asking in staff. One thing I noticed in Ms. Stephanie Niemi's testimony was that instead of providing the PRC with spreadsheet financial models, we instead have access to their regulatory system. Am I understanding that correctly?
Yes, the share file system, I believe, is what you're referring to, and that's pretty standard in cases.
I'm not sure a shared file system. I'm referring to so if we wanted to make alterations in ROE and see how that flowed through to say the required revenue and just their accounting system as it pertains to regulation, we, instead of getting Excel spreadsheets, as I understand we used to do, we have access to their regulatory database system. Is that correct?
Well, I would say we receive their cost of service model, which is Excel spreadsheets. It's just a very large workbook of spreadsheets, and so that is we can access that through the share file.
But that cost of service model is an Excel spreadsheet.
Yes, it's a very large Excel file that includes multiple worksheets within a workbook, an Excel workbook.
Okay, I guess I should ask Ms. Dashino then, because I do remember some portion of Ms. Niemi's testimony where she talked about giving us access to an SPS system, and that downloading a spreadsheet is definitely not what she was talking about.
Okay, so Ms. Dashno is the staff person that addresses the revenue requirement and works directly out of the cost of service model.
Okay. Let's see, the seasonal differential is something that was brought up when hearing examiner Hurst was asking you some questions. Did that seasonal differential make it into the stipulated agreement?
Yes, it did.
And is that I believe that, is it a 20% differential that you had recommended?
Correct, yes.
And is that what made it into the stipulation?
Yes. The company accepted staff's recommendation in its rebuttal case, and that ended up flowing through into the stipulation.
So what's the logic behind having a seasonal differential?
And would you mind directing me to the page that you are referring to in my testimony?
I'm looking at, PDF page 94, we've got an MPRC utility division staff description of proposed rate design process by rate component. And you're looking at the different rate classes, and you have a 20% seasonal differential for some of these rate classes.
Yes.
If I might, Ms. Labor-Tricero, I pulled my questions off page 24 of your direct testimony.
Thank you, Madam Hearing Examiner. Yeah, so, and going to that page that explains some of staff's logic there, I believe that the company was recommending 15% differential, but some of their classes, their current rates reflected a higher differential. For example, I believe the residential class was at 18% and the small general service was at 20%. And staff's concern was that, we didn't want to have something lower than that to have a decrease in those differentials, which could send the wrong price signal to customers. So staff's opinion was that having the same consistent 20% across all customers would continue to send them a clear and consistent signal to manage consumption. And
Is there a difference in the cost of power generation between winter and summer in SPS?
yeah, I believe it would be higher during, for example, during peaks, there would be a higher cost of energy associated with that.
So you're saying to meet summer peaks, they're going to have to run their gas plants more, and that's essentially where this differential is coming from.
You would want customers to try to manage their usage during that time.
I see. And is this something that SPS has historically had, this seasonal differential?
Yes, they have.
Okay, just because I'm wondering to what extent the fuel costs would be taken care of by the FPPCAC. I would guess that the summer prices are going to be, if they're using more gas, that the summer prices would be higher because of the FPPCAC, and you might not need to adjust the the base rate higher or lower.
Yeah, I believe that would be an appropriate consideration there.
Okay. And this may be a question for Ms. Deschanel. Do you have a reconciliation table showing, I guess, the staff's proposed 36 million in revenue, required revenue versus the initial SPS request of 76 million?
I believe that would be a Ms. Deschanel question.
Okay, I will I will make sure to ask her that question. On the time of use rates, is that an issue that you addressed in your testimony, or that you addressed in discussions with SPS?
That was not an issue that was specifically raised by staff in its direct case, but obviously staff agrees with the stipulation. And I believe that time of use rate design can allow customers to more efficiently will allow for more efficient use of energy by customers, which could in turn reduce investments by the company. So I think that's a positive thing, and so staff is agreeable to that component.
Would that be dependent on the approval of the grid modernization application? Would they need to have the smart meters in place in order to implement that time of use rates?
I definitely think that would be helpful in designing effective time of use rates.
Okay, so the stipulation right now calls for the design of the time of use rates. It doesn't really address when and how they might be implemented.
That's correct. And that would be something that would need to be discussed in those workshops.
Okay, that sounds great. I appreciate your work on this, Ms. Labor-Tercero. Thank you for answering my questions.
Thank you.
Thank you, Commissioner. Mr. Bagatko, any redirect for Ms. Labor-Tercero?
Only a little bit, if you please.
All right.
Thank you. Ms. Labor-Tercero, do you recollect the discussion of Section 15 in the contested comprehensive stipulation regarding tolling?
Yes, I do.
To your knowledge, certainly there's no disrespect intended in that provision toward the commission as far as you're concerned. Is that a fair statement?
Yes, absolutely not.
Thank you for that. And then regarding discussion of Section 19 governing rate design and tariff issues. If you have that handy, that's page 9 of the stipulation. There's been some questions regarding how this will go forward. Do you recollect that?
Yes.
And do you recall case number 22-00155-UT, the SPS standby rate case?
Yes, I personally did not work on that case, but I am familiar with it.
And you were peripheral to that case, correct?
Correct.
And you did have knowledge of the proceedings in that case?
Yes.
And it's fair to say that the first phase of that case, if we can call it that, was unsuccessful, correct?
Correct.
And do you remember after the recommended decision was issued in that case, what happened thereafter?
I believe that there was a motion filed by the parties. They were working towards an agreement. And if I recall correctly, the commission granted that motion to allow the parties time to work toward a settlement in that case, which they did and were successful at doing. And that stipulation was ultimately approved by the commission.
And can we call that part of the standby rate case phase 2?
Yes,
And would you say that the parties in the enactment of phase 2 and coming up with the standby rate, their attitudes and approaches were markedly different? Is that fair to say?
yes, that's fair.
Was productive?
I'm sorry, I did not hear that question.
Do you believe it reached a productive result?
Yes, I do.
So do you think that the spirit and commitment that was evidenced in phase 2 of the standby rate case is something that could be replicated in pursuit of what's contemplated by section 19 of the contested comprehensive stipulation?
Yes, I do. And given what happened in that 22-155 case, I believe that the parties will likely work hard to be successful.
Thank you for that. And there is, it's fair to say, marked interest in time of use rates in this case. Is that correct?
I'm sorry, can you say that again?
Do you understand that there are a significant number of parties who are very interested in time of use rates?
Yes.
Very good. So, and as you seem to have been volunteered to be the point person for section 19, are you committed to participating in that process and making it as successful as possible?
Yes, I am.
Thank you very much for that, Ms. Labor-Tesoro. And I think with that, that's all I've got on redirect, Madam Hearing Examiner. Thank you for your indulgence.
Thank you, Mr. Begacco. Any questions based upon my questions, the commissioner's questions, Mr. Begacco's redirect? Ms. Lynch?
Thank you. Hi, Ms. Labor-Tesoro. It's nice to see you so late in the evening.
Hi, nice to see you as well.
Thank you. I just have a few questions to follow up. Do you recall the questions that the hearing examiner asked you about the EAP that was removed from the stipulation?
Yes, I do.
You are not a lawyer, I recall. Is that a true statement?
Yes, that's an accurate statement.
Would you characterize the issue of low income affordability rates as a legal issue?
Well, yes, and in this case, I would, because I believe that the program as proposed by the company is contrary to law. Of course, I am not an attorney, but that is my opinion based upon my experience in prior commission precedent on the issue.
Could it, based upon your opinion, could it be conceivable that an EAP-like program might be just and reasonable and in the public interest because no unreasonable prejudice would exist for such a program?
If it's a
I'm
voluntary.
going to objection, Madam Hearing Examiner. I think Ms. Labor-Tesoro has established that she's not an attorney, and while she does, as part of her professional duties, apply regulatory principles, it seems like the question's calling for her to state a legal opinion. I'm not exactly sure if it can be cured by maybe perhaps reframing it, or if Ms. Labor-Tesoro can.
I'm really just asking her opinion, and I'm not asking for any interpretation of the law, just based upon her opinion as she opinionated upon the EAP as it was proposed in the application. Mr. Begacco?
I would just counter with that. I think the question seems to intimate a separation of the consideration of the public interest from applicable legal principles, and I'm not sure that can be done. If the law states that it's prohibited and impermissible, then getting somebody to say whether or not they think it's in the public interest, if we're not going to parse it out, it seems to lead to a paradox. So I'm just trying to protect my client and keep her from, getting into a position that I think could have implications later on, given that the law is not separable from the concept of the public interest in these regulatory proceedings.
Ms. Lynch?
Well, I just qualified it as an EAP-like program, not the EAP. And Ms. Leyba Tercero has commented within the context of the questions that hearing examiner Hurst asked regarding a program that was proposed by PNM. And so, you know, if the EAP-like program is qualified that way, I don't think it's necessarily a legal question.
I think the witness can answer if she knows. Ms. Leyba Tercero?
Well, I was going to say that if it's a voluntary program, then I believe it would be in the public interest.
Can you provide for us what is a voluntary program?
One that is voluntarily funded by customers and shareholders, and one that doesn't require all ratepayers to pay into a program for the rate relief that would only be provided to certain groups of customers.
So would it could the stipulation be modified to include such a voluntary program?
I suppose that it could be, but you know, staff is in agreement with the stipulation as it currently exists.
The commission has the ability to modify stipulations, correct?
Correct.
Okay, thank you, hearing examiner Hurst. That is the conclusion of my questioning for Ms. Leyba Tercero.
Ms. Leyba Tercero, I just have one question based on Ms. Lynch's question. Are you familiar with section 23, the effect and limitation of the stipulation?
The effect of limitation on stipulations?
Effect and limitation of stipulation?
Thank you.
Thank you, sir.
Let me turn to that page.
I'm sorry, Mr. Lee, I didn't think we'd go this long.
That's all right, Judge.
Okay, yes, I have refreshed my memory on that section.
Okay, let me just pull it. Let me just pull it up. There we go. Okay, section 2223, effect and limitation of stipulation. Item C, signatories further agree that the terms and conditions set out in the stipulation are interdependent and the various provisions of the stipulation are not severable. None of the provisions of the stipulation shall become fully operative unless the commission enters an order approving the stipulation. If the commission issues an order rejecting, not approving the stipulation in total, or modifying one or more of the terms of the stipulation in a way that is unacceptable to one or more of the signatories, then each signatory shall have the right to withdraw from the stipulation to obtain a hearing on the application and to submit testimony regarding the application to advocate any position it deems appropriate with respect to any issue regarding the application to take action to protect its interest and to advocate any position it deems appropriate with respect to any issue. Is that correct?
Yes.
So then, based upon this, any potential modification or rejection of any issue in the stipulation can cause the stipulation to fail. Can it, Ms. Labor-Tesoro?
Yes, that's correct.
And that's built into the terms of the stipulation itself.
Yes.
Okay. Very well. I believe there.
May I ask a follow-up question?
Ms. Lynch?
It's also conceivable, Ms. Leyva-Tesoro, that should the stipulation be modified, all signatories could agree to that modified term that gets added to the stipulation, correct?
That is a possibility, yes.
Thank you.
Very well. Any further questions? Hearing no
Nothing.
question. Mr. Begacco?
Nothing further, Madam Hearing Examiner. I was just going to make that clear. Thank you very much. And thank you to the commissioners and Mr. Lee and the parties for today.
Thank you, Ms. Labor-Tesoro. Appreciate your time. You are excused.
Thank you.
Nothing further from staff at this time. I believe Mr. Begacco has indicated, and we will recess for the evening and continue tomorrow. I will render a decision on whether or not we need to hear from Walmart witness Mr. Chris in the morning. We'll continue on with the staff witnesses where there are questions, and then we will have witness, CCA witness in Mr. Long. And that's how I see things going tomorrow. Any procedural questions?
Madam Hearing Examiner, if you would.
Mr. Begacco?
Do you intend on allowing Ms. Naomi Velasquez's testimony to be stipulated in, or do I need to bring her to the stand?
At this time, I have no questions for Ms. Velasquez. However, should the commission have questions for her, she'll need to be available, Mr. Begacco.
Understood. Thank you.
Thank you very much. And we don't have anything else procedural. Thank you all very much. And we are recessed until 9 o'clock tomorrow morning.